Please open the roll. Okay, the chair is on his way from a meeting. I understand that he'll be here momentarily, and so we're going to suspend until he gets here. We have a quorum, but we don't really have a quorum. Members can leave proxies if they have to go to other committees.
Actually, all four of those I had someone on record saying to the reporter,
Yeah. Taylor sent us an email for 2 weeks. Oh, okay. I was making sure. I was making sure. Yeah, so Taylor DLS emailed me that she's here, but she's calling right now. So it's safe, better safe than sorry.
That's the mistake. Yeah. Kind of get around
Senate Judiciary Committee will come back to order. I understand we have a quorum, right? So the next, yeah, okay. Delegate Herring? Okay. The bill is 1010, House Bill 1010.
Right, Mr. Chair and members of the
Fiscal
committee.
impact statements.
Right,
And
and I have three
I've got
bills.
a note, Mr. Chair, that bill has to be referred to rules. And, which I'd make a motion to refer to rules. That'll meet Friday morning, Delegate.
They'll meet Friday, okay, thank you.
Okay, is there a motion that we refer to rules? All in favor of the motion to refer to rules, vote aye. Opposed, no.
Ayes 10, no 0.
Okay. And 10-0, the motion carries. The bill has been referred to the Rules Committee.
All right,
Meets
thank you,
Friday.
Mr. Chair. I have two other bills
Okay.
today on the docket. One is actually the companion to your bill, the writ of actual innocence,
Yeah.
HB 974.
Okay. 974, writ of action similar to mine?
Mr. Chair, I'd ask staff, is it identical? And if it's not, what are the differences?
Mr. Chair, it's identical, except that Senate Bill 511 has the finance clause. So if we amend this bill to attach the finance clause, it would be identical, and then the bill wouldn't need to go to finance.
Okay. Is there a motion that the finance clause be added to this?
Well, Mr. Chair, may I address that? You all will do what you want to do, but there is money in the House budget for this, over 800.
I
$834,000,
there is.
but-
I think there is. Why they want to do it this way, I don't know.
Well, I'd move to, so we can avoid the
Yeah.
Finance Committee, would move we conform the bill to the Senate bill.
Which means it's going to finance.
No, which means it's not going to finance.
Okay, all right, we're in good shape then. Okay, is there a motion to amend, to
I move to
conform the bill?
conform.
Is there a second? All in favor of the motion, say aye. Aye. All opposed, no.
I move
Okay.
we report the bill.
It has been moved and seconded that the bill as amended be reported. All in favor of the motion, say aye. Aye.
Open shame of doing
Aye.
against this bill.
All opposed, no. Where's Cecily? Up, Cecily?
Ayes 7, no 4.
7 noes 4. It sneaks out.
All right, thank you. And then one other.
Okay?
The marijuana decrim bill, HB 972. It's similar to Senator Evans' bill. We have worked out, instead of avoiding going to conference, we worked out an agreement, and there's an amendment in the nature of a substitute.
Okay, is there a motion to adopt the substitute?
So moved.
Is there a second? All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Now, it's only 67 pages. Should we do it line
Right.
by line?
No, so I think sort of the bigger things I can go through. One is the fee. Senator Evans was $50. Now it's similar, it's the same as mine, which is $25 fee. The amount for considered personal use, Senator Evans was an ounce. Mine was a half an ounce, so the substitute takes it to an ounce. The third thing is the treatment of juveniles. We had attorneys give us a nice explanation between chins and delinquency. The judge has more options with delinquency, although it sounds terrible. Actually, it's better for children because the judge has more options. So this continues to contain delinquency. And then the other piece, which and it's not a study, but my bill had a work group that would collect information and data. So on the very last page, you will see in bold a little bit more clarity that Senator Evan would like to have for the work group.
Mr. Chair.
And includes the, yes.
Okay, Senator McClellan?
On the work group, we did pass a resolution creating a work group. Is
Right.
your work group consistent with SJ 66?
Yes, I would say that they are actually parallel and not in conflict. Because this would be able to start collecting data and information. And I think it's a complement, and I don't think it's a substitute too.
Okay.
Okay.
And I think, yeah.
Yeah, Senator Deeds?
It doesn't create a third work group, because we've got a study at JLARC, we've got a work group through the resolution. Is this basically just add duties to the work group we're planning on, does this just add duties to that work group that we're planning on creating through the resolution, or does this create another work group?
This was part of my bill, and it does have another work group dealing with, if you'll see there, the Secretary of Agriculture and different entities and the Attorney General looking at a framework. And I still say that it doesn't conflict with the resolution, the Senator's resolution, but I think it's a good complement.
My only,
Senator Deeds.
Mr. Chair, my only query is we're gonna have so many different groups looking at this. I would, if
Right.
we passed out of the Senate a JLARC study and a work group resolution, and my suggestion is that somewhere down the line, the work group contemplated in your bill and the work group contemplated in, I think, Senator McClellan's resolution ought to be combined. Maybe broadened, but
Ms. Chair?
Yeah, Senator McCollum.
So specifically, the work group, mine was the JLARC study, which.
okay.
And then Senator Eben had a legislative joint subcommittee that specified several stakeholders that work group would work with. I think the stakeholders look similar, but Delegate Herring's work group is one convened by the secretaries, by cabinet secretaries of Ag, Finance, Health and Human Resources, and Public Safety. So I guess here, the question is, do we just want to, I think we want everybody working on it, but rather than two separate work groups, maybe we can say that the legislative work group in 66 will work with the secretaries that she asked to convene a work group, because I think the stakeholders that are going to be at the table are the same. It's just a matter of, do you want a legislative subcommittee, or do you want cabinet secretaries convening a work group that would not include legislators?
But Mr. Chair, this does include a legislative body, which is the State Crime Commission. And looking at the health effects, I'm not sure the resolution includes that. But I mean, the reality is it is a drug, so we do need to look and consider the health impacts.
Okay. All right, any further discussion? Senator Morrissey.
Delegate Herring,
Yes.
tell me where we are with this substitution with regard to the following issue. Since this simply decriminalizes the possession of marijuana but doesn't make it unlawful, where are we in the substitute as far as police having the authority when they say, I smell marijuana, searching the entire car? Does this substitute, that was a concern among several senators.
Right, understand.
Is
Very
your
much
substitute
understand.
addressing that?
No.
Okay.
No, it doesn't and I honestly, until it's legalized, I don't think that we can constrain law enforcement on their observations until we legalize it. But that's just my opinion.
Any further questions?
Mr.
All
Chairman.
right, yeah, Senator
McDougal.
McDougal.
Can Delegate Herring, I'm
Yes.
flipping through the substitute,
Yes.
page 29. It seems like there's a whole paragraph on dissemination and employers. And am I reading
Yes.
this correctly, that if an employer is hiring somebody to do interstate trucking or a federal security clearance, like a DOD contractor or law enforcement, and they ask a question about whether you'd had a conviction, that they would be guilty of a class 1 misdemeanor?
No. So let me take a step back and explain where I got this inquiry provision that came from the juvenile code. So law enforcement specifically excluded. So law enforcement, EMS, those type of jobs, sheriffs, there would not be penalized. And any employer can ask a question, a private employer can ask, they can do drug testing, random drug testing. In public safety is very important, so I did not want to restrain this for employers asking that question. But to sort of further the goal of not, having past mistakes be a penalty, I modeled this after the juvenile code, which has for employment, you'll see universities, but also local governments with those exclusions of law enforcement and those things that are of high importance in terms of security and safety.
Mr. Chairman.
Yeah, Senator
I'm reading this, it says, an employer or educational institution shall not, in any application, interview, otherwise require an applicant for employment or admission to disclose information. So how is that not requiring them not to
I'm
act?
sorry, can you tell me the line you're reading?
It's 763 through 769 on page 29. I'm sorry I didn't ask you further, but we just got
No,
the
that's all right.
substitute,
Right, so it cannot be a requirement, it doesn't mean the question still cannot be asked. And the employee is still, or the potential applicant is still, there can still be drug testing. But, yes, sir.
Mr. Chairman,
Yes.
I know on
Yes, Google.
some jobs that require security clearances, if an employee can't pass a security background check, they have to provide certain documents. And certainly some interstate transportation licenses require certain information. So if that person says, if I can't provide that information to get the security clearance, so I can't hire you, then they're guilty of a Class 1 misdemeanor?
Yeah. Delegate Harris?
I'm sorry, yes.
Go ahead. No.
So, Mr. Chairman,
And let me-
on 779 through 780 is the penalty of a Class 1 misdemeanor to the employer.
779 says a person who willfully violates subsection B or C is guilty of Class 1 misdemeanor for each violation. And then on the previous page on 763, an employer shall not, in an application, require the applicant for employment to disclose certain information about arrests, et cetera. I think that's what he's trying to say, right? Yeah.
That is. It says what it says, but I will say this, when I looked at the juvenile code, it seemed to model for state employment, and I apologize. I need to find the code section in these words because
Mr. Chair,
Yeah,
I thought there was a limit.
I don't want to pile on, but
Yeah.
I'm reading this sentence that begins on line 766. An applicant need not, in answer to any question concerning any arrest, criminal charge, or conviction, include a reference to or information concerning any arrest, criminal charge, or conviction when the record relating to such arrest, criminal charge, or conviction is not open for public inspection. Does that basically give the applicant the permission to lie?
No, I would not say that it gives them permission to lie.
Okay.
No.
But if they're, if
But
they're-
that gives them permission to not answer.
Say I can't
Right.
answer?
Right.
Okay, because-
But it does not give someone
Okay.
permission to lie. No.
Yeah, Senator Norman.
Mr.
Thank you, Mr. Chairman. I'm late to the party. I was enjoying watching the House Finance Committee operate with their efficiency. As I looked at this language in the summary of the bill, isn't it just more expedient to provide a method for individuals in this situation to have their record expunged and we don't have to go through all of this?
Well, I think, in the answer, we're doing a separate expungement
Well,
Wait, there's a
yeah,
re-
situation.
I would like to ask the question because I have a reason for
Yeah,
that.
go ahead. Answer the question.
If it's more expedient to get expunged, or it to be expunged,
Yes, ma'am.
I would answer no, and this is the reason why. I do not know how long it takes for an expungement to, one locality may be longer than another. I think it's more expedient to have this in our code, the way it is written, as I propose, to then protect individuals from discrimination of employment. That doesn't mean they can't have their record expunged, if we so provide, but. And I think, yes, go ahead.
Excuse me. No, excuse me, I didn't mean to
Yes,
cut you
no,
off.
I'm done.
Mr.
Okay,
Chairman,
Senator
I
Norman.
would share with the gentle lady that, having done quite a few expungements, it is a fairly expedient process on it. And actually, the executive director of the Supreme Court, they have published a form that is online that you just fill it in. And the reason that I am asking is I am mindful of the approach that the House has taken up to this point, and that's not a criticism, it's
No, I
just an
understand.
observation.
Yes.
But from the Senate side, there is a expungement bill that is moving through where all of the bills on the Senate side were rolled into it, and it's a much more expedient process. So I would hope that you would
But-
reflect on it when we have that
I'll
conversation.
reflect, and if I may just quickly though, my concern though is also this, what if someone's expungement petition is not granted? And then so the person's stuck and this sort of gives some avenue.
Yeah, Mr. Chair, we considered a number of expungement
Yes.
bills before, and the complicated ones were sent to the Crown Commission. The simple ones were rolled into Senator Norman's bill and passed, but.
I understand, but then we're picking winners and.
And the language that what doesn't mirror this, but the language that dealt with this subject in Senator Evans' bill was taken out and referred to the Crown Commission. And I worry, I mean,
Right.
if there's an agreement, there's an agreement, but this language, just some of it troubles me.
Understand, and I understand about expungement and sort of, but and I think that there is a way that we're gonna eventually move when dealing with nonviolent offenses or whatever, but I think that this right now is a good way to go. It's modeled after what we have done with individuals who are juveniles, and that it gives us some sort of relief for some individuals.
Senator Morrissey.
Let me ask this question. First
Yes.
of all, kudos to you for working on a very long bill and trying to bring a lot of stakeholders together. Here's my question.
Yes,
I'm applying to a tertiary school, to the university, to a college, or I'm applying for a state or local job, and it says, have you ever been convicted of an offense involving simple possession of marijuana? Do I respond, well, is this for offense that's open to inspection of public records? How do I answer that offense? I mean, that question. Given this statute, if the question is simply asked of me, I'm applying to college, have you ever been convicted of offense involving simple possession of marijuana? How do I answer?
I would answer you by saying the institution should not be asking that question. Should this, yes. But if it doesn't, and you were not, so that's the protection of this. I think you're proving my point. That's the protection of this. Right now, for adults, that can be answered.
Mr. Chairman.
This will provide protection.
Okay,
Further question.
Senator Morrissey.
Here's what we've done. If you look at line 733, it talks, right above it actually, shall not be open for public inspection or otherwise disclosed, provided that such records may be disseminated. And then there are, I think, 11 different exceptions, okay? So it says that it shall not be disclosed except for these 11 exceptions. And I understand what you're saying, that an education institution should not be asking that question. But what if an employer, housing, or some other educational institution does ask that question? I really don't want to be answering it. You really shouldn't be answering me asking me that question. And I'm not sure why you don't just say the following. Take lines 763 and B. It says, and I'm getting down to the fourth line where it says, is not open for public inspection. Why don't we just prohibit any application from asking a question involving the simple possession of marijuana. Instead of going the roundabout way and saying, well, it depends on whether or not it was open to public inspection. Do you see what I'm saying? Just forbid that.
Right. I thought it did.
Well-
I'm sorry, Senators. Employer or educational institution shall not, in any application, interview, or otherwise require an applicant to disclose. So that means that the question would not be
Keep wrote
asked.
it, to disclose information concerning any arrest, criminal charge, or conviction against him when the record relating to such arrest, criminal charge, or conviction is not open to public inspection.
Right.
Why not just say involves the simple possession of marijuana?
Is there a motion?
Mr. Chairman.
Yeah, Senator Sherwood.
Relating to that topic, I may question for the patron, maybe it's just speaking to the bill. But listen, the problem with this approach is that this bill is written as if the only parties to this scenario are the Virginia State Police and the Virginia courts. The problem, and we discussed this in Crim Sub with regard, and when we had our discussion about expungement policy, is that there are thousands, literally thousands, maybe just hundreds, of private companies that they have these web crawlers that crawl over the websites and pulls people's names and information and their charges, and then they sell information about people to schools, to employers, to landlords, to others. And this bill is written as if those people don't exist, but they do. And so what we're doing with this process is setting up a bunch of people to say, nothing ever happened to me. Then either their landlord, their employer, or somebody else goes on a website, pays $50 for a background check, sees they lied, out of their job, they're confronted about why'd you lie, and that's the problem. And that's why we have expungements, because expungements, when an expungement's granted, those private companies have to wipe it from their record, and if they don't, they can be sued. And so we have this existing structure for expungements to deal with these kinds of scenarios. And so we're reinventing a wheel here that I'm not sure has to be reinvented. That's the problem.
Yeah, is there a
Mr. Chair,
change of deeds?
you know,
Yeah,
and
go ahead.
I apologize for this.
No,
We
it's
just saw the
good conversation.
substitute.
It's important.
I'm
Yes.
just not comfortable with
Yeah.
the way, what
Yeah.
you're basically telling people. They don't have to answer questions, and almost you're inviting people not to tell the truth with some of that language, I think. I'd like to just remove from the substitute, the lines from 727 to 780. And maybe that language needs to be replaced with some straight expungement language, but certainly you can get it worked out through conference or when it gets to the governor's office, assuming that's what happens.
Is there a second to the motion?
Second.
Any discussion further? All in favor of the motion to delete lines 727 through 780, pages 30, 28, 29, and 30.
And I guess that will take a title amendment too, Mr. Chair. And
Yeah, and the accompanying
yeah,
other revisions that might be necessary. All right, is there a motion? The motion's been made and second. All in favor of the motion, say aye. Aye. All opposed, no? Okay, that simplifies it.
Mr. Chairman.
Yeah, Senator Sherwood?
Sure, and I had follow-up to Senator Morrissey's first question, which was the question about the odor issue. And we had debate about this on the floor of the Senate. The parties remember I offered a floor amendment to Senator Evans' bill that I had intended to offer in courts committee, but I wasn't here because I'd proxied out. But we heard a lot of testimony in Crim Sub from advocates about people being, from our perspective, profiled, or from their perspective, which I agree with, profiled by people alleging they could smell marijuana all over the place, including from driving cars and faraway places and other things. And that this odor of marijuana constantly being a pretext to get in people's pockets, cars, and maybe sometimes even their homes. And I'd proposed a floor amendment that said no citation for a violation of this section shall be issued unless the officer issuing the citation has caused or to stop or arrest the person for a violation of some other provision of the code. And then went on to say that you can't search or seize anybody based on the odor, and no evidence obtained based on that can be used in court. And I mean, I would like to reoffer that amendment to this bill. I don't know if the courts committee. Yeah, I can do that. Huh? No, it was not successful.
Well, we're putting too much stuff in this bill. It's big enough as it is. It's ready to go, I think.
Ms. Chair,
Yeah, Senator McClellan.
Before we're done, and I don't want to interrupt his line of thought, but I'm going to have some amendments to the work group before we're done.
I withdraw my request.
All right, is there a motion on the bill?
I think
Not
the
yet.
patron wanted to say something. I could
No,
see you
no, I am
chomping at the
good.
bit. Go
I am
ahead.
very good. I am
Okay.
very good. I just
Okay. Any-
see the world a little
any other
differently. Sorry.
questions?
Ms. Chair,
Yeah, Senator McClellan.
I have a couple of amendments to the work group, mainly just to make sure, I mean, they should be pretty self-explanatory, but on line 1798, after Attorney General of Virginia, insert "or his designee."
Okay, is there a second to that motion?
I
I'm
have
sorry.
several I want to do in
Okay,
a
go
block. if I may.
1798.
I'm sorry, Mr. Chair. I guess I may have something different. On 1798, I don't see.
1793,
Okay.
after Attorney General of Virginia, insert "or his designee." And you would insert the same thing after Commissioner of the Department of Taxation. On the next line, after the Commissioner of the Virginia Department of Agriculture and Consumer Services. And that makes this consistent with what we did in Senator Evans'
Okay.
resolution, but it also, just as a practical matter,
Right.
you may not get the Attorney General directly.
Right. No, absolutely.
So I move those amendments in the
Yeah,
block.
let me ask a question to staff. When you say the Attorney General, don't you also mean the Office of the Attorney General, more generally?
Right. And I accept the Office of the Attorney General. This is language that the Senator provided me, so I'm happy with Office of the Attorney General.
Rather than his designation?
Mr. Chair, when you use the Attorney General or his designee, it's basically used interchangeably with the office. So I think Senator McClellan's amendment kind of makes that
I
clear.
guess my question is, when you say Attorney General, you also mean the Office of the Attorney General, don't you?
Not necessarily.
Okay, all right. There's a motion been made in a second. Any further discussion?
I have a discussion on the
Yeah.
amendment. On the amendment.
Yeah,
Mr. Chairman.
Senator Morrissey.
To either the patron or Senator McClellan, the individuals in that group do not include any lay individuals who have been involved in this decriminalization process at all. It's a lot of government officials, but no lay individuals. It seems like if we're going to convene a work group to study this issue, those organizations, lay organizations that have been so intimately involved in this process ought to be a stakeholder.
Mr. Chair, if I may respond.
Senator McClellan.
You do have one in here, but again, just let's go back up 50,000 feet. So the Senate has passed one resolution directing JLARC to do a study of marijuana legalization. And then we passed another resolution establishing a legislative subcommittee of 14 legislators, 5 non-legislative members, and ex officio members, some of whom are included in your bill and some of whom are not. So we already have those two. And now we have a work group convened in this bill by the Secretaries of Agriculture, Forestry, Finance, Health and Human Resources, Public Safety, and Homeland Security. But we don't tell any of them to talk to each other than the 2 Senate resolutions said JLARC talked to the subcommittee, subcommittee talked to JLARC. And what I'm trying to do is make this third work group consistent with the first 2 and say, now you all talk to each other, because they all have to issue a report on the same day. And they all need to be coordinating and talking to each other. So that's what I'm trying to do with this, if we decide we want 3 different groups looking at the same subject.
All right, any further discussion?
Mr. Chairman.
Yeah, who's, one more? Okay, Senator Stanley.
Mr. Chairman, Delegate Herring.
Yes.
With regard to this marijuana decriminalization work group, will there be samples? And if so, will snacks be served?
All right,
Not
Asking
until
for a
it's
friend.
legal.
okay.
Just asking for a friend.
Yeah.
Okay. All right, We have an amendment here
Mr.
that's
Chairman.
on the floor.
Mr.
Is there any
Chairman.
discussion? Senator Stewart.
I wanted to add to the amendment that Senator Stanley be appointed to the work group.
We're going to veto that. All right, all in favor of the motion to amend as articulated by the senator from, the junior senator from Richmond, say aye. Aye. All opposed, no. Motion carries.
Mr. Chairman,
Yeah, Senator Deeds.
I move that we report the bill and re-refer it to finance.
It's been moved and seconded to report the bill and refer it as amended, and the substitute as amended to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 4.
10
Thank
votes
you.
for,
Thank
the
you, Mr.
motion
Chair.
carries. The bill is reported and re-referred to finance.
Thanks, everyone.
Thank
Thanks.
you, okay. All right, the next, let's see, where are we? Who's next? Yeah, okay, all right. Yeah, Senator Delegate Wampler, 1166. Accounts filed by fiduciaries, reports filed by guardians, identical to, wait a minute, is this one we wanted to pass by? I can't remember. No, not this one, okay. Identical to Senator Chafin's, reported out 15-4. Is there a motion okay. All right, House Bill 1231, Delegate Wilt, Department of Criminal Justice Services, Crisis Intervention Team Training. It's identical to my bill, Senate Bill 494, reported out 14-0. Is there a motion that we report these bills on a block? It's been moved. Is there a second that we report the bills on a block? Is there a second? Second. Any discussion? All in favor of the motion to report House Bill 1166 and House Bill 1231 in a block? All in favor of the motion, vote aye. All opposed, no.
Ayes 14, noes 0.
14-0, okay. So which one should we do next?
Mr. Chairman.
All right, block two, contested identical bills.
Mr. Chairman.
Yeah, Senator Serval.
Senator Peterson asked that House Bill 1391 go by for the day. I've
Right.
discussed that with the patron. He's aware of it. And
Right.
having said that, I so move.
Yeah, without objection, Senate Bill 1391 would go by for the day. That's Senator Lefkowitz's bill on deeds of trust. House Bill 1627, Delegate Bourne's bill, threats and harassment of certain officials and property, identical to Senate Bill 997, my bill, which is PBI 9-5, although it's a great bill anyway. So Delegate Bourne, maybe you'll have better luck. Are you here, Delegate Bourne? Okay, amendments? Okay, let's hold that off then. Okay, all right, we'll put that off. The next in a block is some of bills. House Bill 298, Delegate Tran's bill, misdemeanor sexual offenses, similar to Senate Bill 724, Senator McClellan's bill, reported out 15-0. And House Bill 618, Delegate Plum's bill, hate crime, gender. We can't do that? Okay, all right, let's take up House Bill 298. Is Tran here, Delegate Tran? Huh? It's House Bill 298.
Mr. Chair, I can present that.
Okay, Senator McClellan,
So, Mr.
identical to
Chair,
your bill.
yeah, Mr. Chair, this is similar to, but not identical, a bill that I had that changed the statute of limitations for, related to misdemeanor sexual offenses where the victim is a minor. Currently, the survivor, I'd rather say, has until they turn 19. And my bill simply changed it to give them a full 5 years, so they have until they're 23. The House version is slightly different in that it only makes that change where the offender is an adult. So under the House version, if it is a minor who is accused, if the offender is a minor, that's what she told me. Is that right? Okay.
Go ahead.
All right, Mr. Chair, this bill is similar to Senate Bill 724, which was Senator McClellan's bill. Senator McClellan's bill had it where the offender was an adult, and the victim was a minor, would extend the statute of limitations for additional 5 years when the survivor reached the age of majority. In Delegate Tran's bill, the difference is the offender has to be an adult at the time of the offense and 3 years older than the victim at the time of the offense, which was designed to prevent a 18-year-old who might be in high school, the victim may be 17, that would still be under the existing statute of limitations. The concern was that 18 and 17 may be too closely related, so the House version was a 3-year difference, so the offender would have to be 20 and the victim would have to be 17.
Mr. Chair,
Senator
That's
Dees.
what they did to mine.
I move we conform this bill to Senator McClellan's bill.
Is there a second? Okay, any discussion? All in favor of the motion to conform House Bill 298 of Delegate Trans to Senate Bill 724, Senator McClellan's bill? All in favor of the motion, say aye. Aye. All opposed, no?
Mr. Chair,
Yes. Senator McClellan.
just so that we're clear on what we're voting on now. So the House version right now, which is in our packet, all it does is change the statute of limitation to 7 years after the victim reaches majority. What Charles just mentioned is what the House did to my bill. So the question for the committee is, do you want to simply change the statute of limitations, regardless of how old the offender is? Or do you want to do what the House did to mine, that Charles just said, where if you have a 17-year-old who sexually abuses a 16-year-old, the statute of limitations would still be a year?
Well, the motion was to conform the House bill to the Senate bill that passed the Senate.
Well, the version that passed the Senate was just 5.
Well, that's the
what y'all wanna do,
motion.
that's fine.
5 years if the offender is an adult. If the offender is an adult, and the House bill was a little bit less than that standard a little bit.
Okay.
I prefer the stronger standard when you're talking about juvenile victims.
So okay, then I just want to make sure we know what we're
Okay.
conforming to.
Are you ready to, okay, the motion is made to conform House Bill 298 to Senate Bill 724 that passed the Senate. All in favor, moved and seconded, all in favor of the motion say aye. Aye, all opposed no. Is there a motion to report?
Move the report.
It's been moved and seconded to report House Bill 2,
Report, you refer to finance.
no? Okay. To the motion to report the substitute to House Bill 298. All in favor of the motion, vote aye. All opposed, no. Okay.
Ayes 14-0.
Okay. We're not going to go to Senator Delegate Plum's bill. Mullins, is he there? Mullins here? No. Van Valkenburg, House Bill 759. Is he here? All right. This is a SLAP bill. It's similar to Senate Bill 375, my bill. It was reported out
Motion passed
14
by
to 0. We're going to conform it. All right. House Bill 759, Delegate Van Valkenburg. It's your SLAP bill. We're going to conform it to my bill.
Yep.
Mr. Chair, I move that we conform the bill to your bill, Act 75.
Okay. All in favor of the motion to conform House Bill 759 to Senate Bill 375, say aye. Aye. All opposed, no. Motion carries. So the motion to report. All in favor of the motion to report the substitute to House Bill 759, vote aye. All opposed, no. Obenshain. All
Ayes
right.
13, noes 1.
Can we do my
Okay,
other
thank
one?
you very much.
Can we do my other one?
Yeah, where's your other one?
It's House Bill 1570.
House Bill 1570, possession of tobacco products, nicotine vapor products, et cetera. Okay, we don't have a similar bill in the
No.
Senate? Okay.
No.
All right, House Bill 1570, Delegate Van Falkenberg.
All right, thank you, Mr. Chairman. Mr. Chairman, members of the committee, so last year when we raised the age for vaping and tobacco to 21, we did not create a research exemption. And so VCU, among other places, has the Tobacco Research Institute that looks into research on the regulations that come out of the FDA and on cessation efforts. And a lot of the work they do is on younger people, and what they find is that in their research, younger people react differently to older people on these products. And so they're asking for a research exemption so that they can continue to work. You know, the VCU Institute, and this came to me from the guy who heads it, who is my constituent. The VCU Institute does a lot of work for the FDA, the NIH, on will regulations be effective? So for instance, a good example of that would be if you're trying to ban flavors for vaping. Will that work at cutting down on vaping for minors versus the adult population? There's other institutes across Virginia that work on cessation efforts, and will it work on minors versus will it work on the adult population? And an example he gave me that I think is a good example is they found that when minors smoke hookahs, they smoke them faster and they take more hits off a hookah in a short period of time. And so when you're trying to create effective cessation efforts or you're trying to create effective regulation at the federal level, you need to react differently based on the age group. And so if you look at the language in the bill, it's lines 28 to 32. This is just for research that fits under applicable federal regulations or research review committee pursuant to state law, right? So this is limited to certain actors. One thing that came up on the House side was the fear that we'd be encouraging young people to smoke. There's a multi-step process that people have to go through to be involved in one of these studies, which includes being asked questions up front.
Mr. Chairman? Yeah, Senator Obenshain.
So if we were so inclined, could we do these tests on animals under our current animal testing law? But we could do them on teenagers.
Yeah, is there?
I would respond to the senator. I would respond to the senator that vaping is an epidemic among minors, not among sheep.
I understand, but we've gone past sweeping animal testing prohibitions. But pointing out the irony here, that we're not allowing animal testing, but we're allowing teenager testing.
But once again, I would respond to the senator that we're not taking kids off the street and hooking them up to a vaping machine. It's kids who are already smoking, who they know are smoking through a rigorous process that includes a blood test to make sure to see that they actually have levels of nicotine in their system. So it's trying to cut down on smoking, and it's trying to ensure that regulations work. So I don't,
So it's the societal good and the greater good that is.
I take your point, Senator, but
Mr. Chairman.
Okay, Senator McDougal.
Mr. Chairman, I just want to make sure I'm understanding. So that we're leaving in here the fact that if you are under 21 and you possess tobacco, you're going to be exposed to a 4 times higher penalty than if you were possessing marijuana. You didn't change that in the bill.
Yeah. Delegate.
That sounds like a different bill. I would reply to the senator. This is not a bill about marijuana. This is a bill about trying to ensure that we're doing what we can to cut down on vaping.
Senator McDougal.
I'm going to vote for the bill, but I just want to point out for the committee that the penalty for the individuals that we're now going to exempt them from is a $100 fine, whereas if you possess marijuana under the bill we just took up, it's a $25 fine.
Okay. Any other body want to say anything? All right. Anything else you need to say about the bill? All right. I think we're trying to convince teenagers not to do
Mr.
this.
Chair, would you accept the motion now?
Yeah, the motion.
Move to report.
It's been moved to report. Is there a second? Senator Deeb seconds. All in favor of the motion?
Second, Mr. Chairman,
Yeah, Senator Serval.
I'm sorry. I just think it's important that we take any input from the public if there is any. I'm assuming there isn't any.
Is
But
anybody in favor of the bill? Anybody against the bill? Okay. All right, go ahead. It's been moved and seconded to report the bill. All in favor, vote aye. All opposed, vote no. Okay.
Ayes 14-0.
Motion
Thank you, Mr.
carried,
Chairman, members of the
14-0. Okay. Now, next, who are we doing next? John, which one? Delaney? Okay. Which number is that? Okay. It's House Bill 806, Delegate Delaney, Criminal Injuries Compensation Fund.
Yes,
This
Mr.
is
Chairman.
similar to Senate Bill 949 of Senator Lucas, passed 9-5-1. Okay?
So yes, Mr. Chairman, that bill was similar. However, I know that bill in the Senate version that's coming to the House, there is no funding for that language in either budget. What I did to my HB 806 to recognize that the funding was likely not going to be available in the budget, but that we would be able to take some steps in this space was to make some amendments that are before you today in the House version that address the issue with no fiscal impact. So to refresh your memory on the issue, this is a bill that dealt with some of the Joint Commission on Healthcare's findings on state of forensic nursing in Virginia. That was a study I'd requested last year, and a number of recommendations were made. This bill addresses several of those. So the version of the bill before you that now has no fiscal impact addresses the concern of the SART team makeup. So currently a sexual assault response team, they meet annually. We are adding several members to that team and allowing electronic participation, as was one of the recommendations. There were also a number of concerns about the reimbursement for forensic nursing. Right now, the forensic nurses and not the hospitals or the provider billing office are responsible for the billing. They're required to complete and submit paper claims by mail. It's an onerous process that we recognize is complicated. We did not have funding to directly handle some of those billing needs, but we recognize that this is something that does need more understanding and more study. So this bill also creates a work group that, among other things, will address some of those questions about the reimbursement concerns and hopefully come back with some recommendations that we may be able to see in a future budget.
Is this in conflict at all with Senator Lucas's bill?
Well, Mr. Chair, if I could.
Yes, Senator Dees.
When you talk about a substitute, you're talking about the House substitute.
Yes, Mr. Chairman, I think I probably used the wrong language to describe it. The bill before you is intact as we'd like you to hear it, but I described the evolution of that bill through the House process.
And Mr. Chair, this bill has no fiscal impact.
That is correct, Mr. Chairman,
The
Senator.
Senate Finance Committee still requested it. That's why I wondered.
Okay, is there any further discussion?
Mr. Chairman.
Yeah, Senator McDougal?
Can I just make sure I understand what the difference between Senator Lucas's bill and this one is from staff? Because if I'm looking at it, this bill is really amending the membership in subsection B and adding subsection C, and I think Senator Lucas's bill did that plus a number of other things. Is that correct?
That's correct, Mr. Chair. To answer Senator McDougal's questions, one of the main, I'd say, the difference between Senator Lucas' bill and the bill we have before us is Senator Lucas's bill eliminated a requirement that the victim of sexual assault report the assault to law enforcement or undergo a PERT kit to be eligible for compensation for uncompensated medical costs through the Criminal Injuries Compensation Fund. This bill also does make some slight changes, as the delegate mentioned, to the work group to look at how to reimburse those on medical costs.
Mr. Chairman, I move to report and re-refer if it
Okay.
has to go to finance.
Moved and seconded to report and refer to finance. House Bill 806. All in favor of the motion, vote aye. All opposed, no.
Ayes 14-0.
14-0. Congratulations, Senator Delegate Delaney.
Thank you,
Thank you
Mr.
very much.
Chairman. Thank you, Senators. I also have before you HB 1524.
1820.
1524?
1524, okay. 1520. Wait a minute.
When you're ready.
1524. Okay, here it is. Prostitution.
Yes, Mr. Chairman, and members of the committee, this is a bill that came out of the Crime Commission's study of human trafficking in Virginia. This was one of the recommendations. Currently, under Virginia law, only paid sex acts that involve penetration are considered prostitution and punishable by law. This leaves sex traffickers and other individuals who exploit women the ability to open what we see really becoming a pervasive problem around Virginia, which is the illicit massage industry where victims of trafficking are exploited. So this bill expands the definition of prostitution to include intimate touch or intimate touching of intimate or intentional touching of intimate parts, which allows that law enforcement is able to properly prosecute sex traffickers and those who are involved in this form of exploitation.
Okay, any discussion?
Mr. Chairman.
Yeah, Senator Sherrill.
Thank you, Mr. Chairman. So I have, it's probably a question for council, but I think what this is mainly after is, well, maybe the patron can confirm for me. This is really after what's colloquially known as happy endings, right?
That is correct, Mr. Chairman.
Okay.
Senator.
So the question for council, I know that at least in Fairfax County, we've dealt with this issue by the locality licensing massage parlors, and then they make this type of activity a violation of the massage parlor license, and then law enforcement then has the authority to deal with it that way. And is there some reason other localities haven't been able to do that?
So I don't know if that's a question for me or
Well,
for
either
council. We also have
maybe
Crime
Mr.
Commission.
Chairman,
Crime Commission is also here today.
Okay,
and
maybe
like-
Crime Commission can fill me in.
Crime Commission, he's going to explain this.
We were hoping I might be the only one to speak to this, Mr. Chair.
Good afternoon, Mr. Chair, members of the committee. Senator Surville, in response to your question, that is correct. Localities can pass ordinances dealing with illicit massages. However, those would be misdemeanor offenses. The challenge that we're seeking to address is that for the commercial sex trafficking felony offenses is that because as you described, happy ending is not technically a act of prostitution under law, therefore it cannot be treated as a felony, a violation of the felony commercial sex trafficking statute. So law enforcement can pursue these massage parlor operators for misdemeanor level offenses. However, they cannot pursue them for the more serious felony level offenses dealing with the human trafficking.
Mr. Chairman.
Okay, Senator Sherrill.
Secondary question, I guess, for the Crime Commission. I mean, I appreciate for the last 10 years I've served, the Crime Commission always finds out new ways to come up with new felonies. But I guess my question for you is, the way this is drafted, it would seem to me to also criminalize lap dances. Is that right?
No,
I can speak to that if you prefer. With the section of the code that we're in, when on line 16 touches the intimate parts as defined in, and then it has the code section of another person with the intent. When in that code section, the section of code that this is in, intimate parts are either defined as intimate parts or intimate parts with clothing. And so the fact that this does not say, has no mention of clothing means that it is implied that that there would be no clothing in this scenario. So in a scenario where there is clothing, then this would not apply.
Okay.
Mr. Chairman.
Any further discussion? Yeah,
Mr. Chairman. Mr. Chairman, maybe it's Crime Commission question for them too, is I just pulled up because did not recall the definition for 18-267-10. I look at intimate parts and it means some of the things we think it means, genitalia, anus, groin, but it also means breast or buttocks, and that's not just defined to a male or female as well. And I guess it's tagged back to gratify, could a massage of a chest muscle to relieve tension be criminally an offense under that definition?
Mr. Chairman, Senator McDougall, I don't believe it could because there has to be the sexual intent to arouse or gratify. I think that's more, I believe there's definitions regarding massage therapy in the code that would deal with the massage of those muscles for therapeutic purposes as opposed to sexual purposes.
Okay, any further questions? Anybody want to speak in favor or against this?
Mr. Chairman.
Steve Benjamin.
There is a definition of intimate parts, but it does not specify that they would be unclothed or clothed.
I'm looking at it right
And
now.
so to ensure that the bill does what the patron wishes, on line 16, for example, it should read, touches the unclothed intimate parts. A similar addition of the word unclothed would appear also on lines 20, 36 and 45 in front of the words intimate parts.
Okay.
Mr. Chairman.
Yeah, first let's deal with this.
I am dealing with this.
Want a motion? Okay, Senator Serval.
Being very aware of the fact that there was a certain film that involved putting baby in a corner that was filmed in the Commonwealth of Virginia, it sounds to me like a good amendment, so I'd move those amendments.
All right, is there?
Dirty dancing.
Is there a second to this?
Mr. Chairman.
Yeah, Senator Overchain.
Could you tell me what the amendment is?
Yeah, read the amendment, Mr. Benjamin.
Wherever in the bill you see touches the intimate parts, you would insert the word unclothed so that it reads touches the unclothed intimate parts.
Okay, that's the motion. Any further discussion? Yeah, Senator Overchain. Okay, all right. Is the motion been made and seconded? All in, somebody wants to speak in favor? Yeah, here we go.
Mr. Chairman, members of the committee, John Mahoney here on behalf of the Virginia Association of Commonwealth Attorneys, and for the reasons stated by the patron, we support this bill as it fights human trafficking.
Okay. There's a motion that's been made to amend the bill. All in favor of the motion, vote aye. All opposed, no. No. The motion carries.
Mr. Chairman.
Okay, Senator Morrissey.
Question for the patron. Delegate Delaney, you have said several times that the genesis of this bill is to address sex trafficking or human trafficking, and those words and those phrases arouse a certain passion in people that that's wrong. But is it nowhere in this bill does it mention sex trafficking or human trafficking? Does it?
So, Mr. Chairman, I would say to the senator, the bill specifically does not address trafficking as other parts of this same code section that I would say also address trafficking don't specifically address trafficking. The issue that that this addresses, however, is the way that victims are exploited. There is estimated to be at least 9,000 of these sexual massage illicit massage businesses around the country. It's estimated that over 200 of them exist in Virginia. There had been a recent observation of several in Northern Virginia where they saw none of the women who work there ever leaving, but they saw hundreds of customers coming in throughout the days and the weeks. So there's a strong correlation between this type of practice and human trafficking. And it's been studied beyond the Crime Commission study, both across the country and here in Virginia, that the type of definition that we're trying to aim here has become kind of a loophole that's been identified in human trafficking conditions here in Virginia, that because this act is not captured in this code and as part of prostitution, it limits law enforcement's ability to prosecute the trafficker and the buyer of exploited women. And it also denies those victims the opportunity to have that engagement where they are often first identified and assisted and put into proper restoration services.
A follow-up question.
Yeah,
I understand, and you've connected the dots about the illicit massage industry using women that are being trafficked. And you've made a compelling case. Is that solely what this bill is trying to prescribe, those women that are caught up in illicit and human trafficking?
That's the intent of the bill coming forward. That was how the Crime Commission determined that this was a necessary step to help address that.
What about those women that want to participate in it? They are not involved in human trafficking. They go home after they work do their job. This bill, you would agree, captures that population of women.
Mr. Chairman, I would say that it does, and that's going to become, I think, a question of the committee's preference on how we view that. I think that that is an ongoing debate about how we deal with prostitution laws and statutes and how that captures the variety of individuals who are involved in that, including those who are trafficked. And I think that, I agreed to carry this bill and support this bill for the reason that there is such a strong correlation between this industry and human trafficking. And while there may be individuals who are consensually participating in this kind of business, I think that the evidence is very clear that it has an incredibly strong correlation to human trafficking. It's been studied across the country. There's a very strong correlation with specific victims from specific countries that are brought here either through human trafficking or engaged in debt bondage, and that this is a massive enterprise that's being run across the country. And that correlation, in my opinion, is so strong that this is a right course of action, understanding that, you know, there may be some differences of opinion about individuals who participate in otherwise lawful sex work. That's, I think, going to be a philosophical question for the members on the committee.
Mr. Chairman.
Yeah, Senator Stewart, we got other bills here. So.
Mr. Chairman, to that point, I think Delegate Delaney's done a really good job with this bill. Some of us have been looking at this for a year or two, and she's exactly right. There was a hole that allowed this to continue. It is directly connected to sex trafficking. We're seeing it happening up in northern Stafford County and try to figure out how to deal with it. I commend her for bringing the bill because it's a tough one to bring forward and to explain as you've done, and you've done a good job of it. I'd move to report the bill.
Yeah, Senator Obenchain.
Yeah, Mr. Chairman, I just want to echo what Senator Stewart said. This Crime Commission's looked at this for a number of years. This has been a recommendation for, I believe, a couple of years. Bipartisan, unanimous recommendation by the Crime Commission. The human trafficking fight is largely to fight for people who don't have other people to speak out for them. Delegate Delaney has done a very good job over the past couple of years standing up for those who don't have a voice in this body. And I think,
Well,
Go ahead.
I do second the motion, Mr. Chairman.
All right, it's been moved and seconded the motion be reported. Yes. Yes, Senator McClellan.
I have a question. I also support the bill and support what you're trying to do. I just want to be clear, under your bill, both the person performing the happy ending and the person receiving it could be charged.
So, Mr. Chairman, I will be happy to speak to that because I've worked fighting human trafficking starting about 10 years ago, and the fact that we have a system where we criminalize prostitution, and that is often the way that victims of trafficking are identified. It's a very imperfect reality that I encountered this working with domestic minor trafficking victims. We often saw children arrested and charged with prostitution who were, by nature of their being the age that they were, sometimes 14, 15, 16 years old, charged with prostitution when there was a clear trafficking dynamic. That is, I think, a signal to a much bigger problem and a much ongoing need for us in this body and advocates that fight human trafficking to recognize that this is an ongoing conversation that needs to happen. But what we see in practice, law enforcement, both local and federal, have come a very long way in my time working in this space to be able to recognize victims of trafficking. And the reality is that while, yes, under this code section, we are making it a crime for what the victim is doing, and that is kind of the vehicle. However, law enforcement has come a very long way to identify when they're walking in this scenario, to recognize when this is a victim of human trafficking, and to respond accordingly.
Mr. Chair.
Wait, Mr. Chair.
We do have a motion.
Follow-up
Yes,
question.
Senator McClellan.
Follow-up question. And I agree with everything you just said. But you would also agree, and this is a softball, you would also agree that under subsection B, that the person soliciting the happy ending could also be charged.
And that, Mr. Chairman, I would say is mostly the point of this, is to be able to have this vehicle. It will allow both the trafficker and the person that are paying for something where they're exploiting someone to be charged. And that is the heart of what we're trying to do here.
I just want to make sure
And
that's clear.
that is the expected outcome of this from all the members of law enforcement, both local and federal, that I've spoke to about this bill.
Mr. Chairman,
All right, Senator Obenchain.
if I can just add to that, the real victims are the folks who are being trafficked. And what we heard time and again is that without the ability to charge, very often there's an inability to get them services that they very badly need. I also heard repeatedly from Henrico County and others that they do not prosecute these victims. They have used the ability to charge as leverage to get victim service, particularly where they do not, particularly children who do not view themselves as victims.
Mr. Chair,
We've
just final
pretty
point.
exhausted this.
Mr.
Ms.
Chair,
McClellan,
final point.
last question.
As someone who also has been on the Crime Commission and has worked to fight human trafficking, my only point is, too often, the focus is, there is no focus on prosecuting the real reason for the trafficking, and that is the customer. And what I like about this bill, what I like about this bill, and I want to make sure it does not get lost in the discussion, is if we don't start going after the customers, human trafficking will never end, and this gives the prosecutors another way to go after the customer. And I just want to make sure that point is absolutely clear.
Thank
you, Mr. Chairman.
The motion been made and seconded.
Mr.
to
Chairman.
Report. Last question, Senator
It's not a
Sherwood.
question. Speaking of the bill, two things. First of all, localities can already do this. And we already have it in Fairfax County. We have it in Prince William County. We don't have it in Stafford. I don't know why the Stafford board wants to put it on us, which they've been trying to do for 2 years, but they can do it themselves. So the tools are already out there for what we're about to put in the Code of Virginia. Okay? We don't have to, number one. Second thing I want to say, Mr. Chairman, is just because the Crime Commission looked at something doesn't mean anything to me. The Crime Commission has had an agenda for the last 10 years because of the people who have been put on there, and I haven't agreed with any of it, okay? Just because it was bipartisan or whatever, DELSA doesn't mean anything to me. So the Crime Commission, I think, is about to change. We're hiring new staff for it, there'll be new members put on it. Maybe it'll change, but in any event, from my perspective, the policy choice we're making is taking local authority and putting it into the state code with this bill as it's been amended. That's what we're doing. This isn't any great big huge step. We're putting it in the state code. And I'm not sure we need to do that because I haven't seen what the problem is where localities can do this if they want to already. So I'm not really clear what the problem we're trying to really address with this bill has now been amended.
Moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 11, noes 2.
Ayes 11, noes 2, the bill is reported. Okay, thank you very much.
Thank you, Mr. Chairman. Thank you, committee members.
Jeff Campbell, I think, is here with the bill in next order here. I'm going down the list. Okay, Jeff. Delegate Campbell.
Mr. Chairman, I think there's a substitute as well.
15, the bill is Senate bill, House Bill?
1725.
1725. House Bill 1725. Okay, it's the last bill on the list here. Judicial assistance.
Mr. Chairman, this is a feeble attempt to try to solve what I perceive to be a very simple problem. As many of you know, many localities across the state provide secretarial staff for the circuit judges. That staff ordinarily is paid for out of local money by the Board of Supervisors. That has created some issues, particularly in Southwest Virginia with respect to the supervision and control of those employees. And as a result of a number of complaints across those circuits that are contained within the substitute, I've brought this bill forward to try to provide some clarification about who the employee actually works for and under the discretion of.
Okay. Here's the substitute. Is there a motion to adopt the substitute? Been moved and seconded to adopt the substitute. All in favor of the motion say aye. Okay, all right.
Mr. Chairman, I think Delegate Campbell also wanted to add 2 words to the substitute on line 13. After shall serve at the, he wants to add sole direction, and also on line 14 and under the sole supervision.
Serve at the sole direction and supervision? And under the sole supervision of such judge. Okay, all right. Is there moved and seconded to adopt the line amendment? All in favor, say aye. Aye. All opposed, no. Motion carries. The line amendments is adopted.
Mr. Chair, Mr. Chair, can I ask a question?
Yeah, yes.
Is the problem in these circuits between the clerk of court and the judge? The clerk of court's trying to boss the judge's secretary around or something?
Mr. Chairman, I would say to the senator, that's not the case, actually. I think that the issue really runs between the boards of supervisors and the judge. Ultimately, the judges, if they have problems with the control or supervision of the employee, they have had to resort to actually appearing before boards of supervisors and asking for authority to be able to discipline that employee. In some cases, in Washington County, for instance, they've actually adopted job descriptions that clearly identify that employee works for the judge and only the judge. That's not been the case across all of the jurisdictions, and so it's a reason I brought the bill. Quite frankly, there's no opposition in the House. It did draw the angst of some circuit court clerks in Northern Virginia, and thusly we've redrawn the bill to apply only to those circuits that are in substitute.
Applies to the 27th, 28th, 29th, and 30th judicial circuits. Senator Morrissey.
To the patron, good afternoon.
Good afternoon.
An employee hired and paid by a county or city to assist with the administration of a judge's office. Whom are we speaking about? Are we talking about a law clerk? Are we talking about a deputy clerk?
Mr. Chairman, I would say to the senator that no, we're talking solely about the secretary that serves the judge. Law clerks are not contemplated by the bill.
The question I have is, doesn't the secretary to the judge work for the judge? And why is this needed? I don't understand.
Mr. Chairman, ordinarily I would think that would be the case. History has proven different.
How could the Board of Supervisors get involved in that?
They have. I promise you, this is an actual problem. It's not something I've invented.
All right, okay. Any further discussion? Is there a motion we adopt the substitute as amended? Well, we just did I think we just did the line amendments. All in favor of the substitute as amended be adopted. All in favor say aye. Aye. All opposed, no. Motion carries. Is there a further motion that we report the substitute? Doesn't have to go to finance. Okay, all in favor of the motion to report the substitute as amended, vote aye. All opposed, no. Vote no.
Ayes 11, noes 3.
11 to 3. The motion, the bill is reported.
Thank you, Mr. Chairman.
Okay, thank you. Okay, the next person on the line is Delegate Hayes.
Okay, so what about
Delegate Hayes here? Okay, there you go. Which bill is this?
We want to have control of
909?
Yes, sir.
All right.
We want to engage
Welcome.
consensually.
Thank you, Mr. Chairman, members of the committee. You have before you House Bill 909, which is the identical bill with your Senate Bill 513, carried by our chairman, Senator Edwards.
Identical?
Those established.
Yes, sir.
Mr. Chair, it is similar in the sense, it is identical with the exception of your bill had a enactment clause which said the bill was a resolution to oppose. Delegate Hayes's bill had a separate resolution, did not have the enactment clause, had a separate resolution. And it would be my recommendation to not conform the bill, leave the bill as is, because the separate resolution needs to be enacted to do what the bill is supposed to do.
Okay.
And send it to finance.
All right. It's driver's license suspension for certain non-driving related offenses. Okay. Is there somebody who wants to speak in favor of the bill?
Nikki Zamosny, Deputy Secretary of Public Safety and Homeland Security, here to support the bill. Thank you, Delegate Hayes.
Anybody speak against the bill? Okay. Is there a motion that we? Been moved and seconded that House Bill 909 be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 13, noes 1.
13 to 1. Congratulations. Thank you.
Thank you, Mr. Chairman,
Appreciate
members
it.
of the committee.
Okay, the next person is Delegate Hope. Is he here? Yeah, there he is. Couldn't see him.
Yes,
Delegate
Senator.
Hope.
I have two bills, House Bill 304,
I'd like to continue to the 2021 session.
House Bill 304, to be continued. Carry over. For the-
304, yes.
Carry over for the year, okay. Is there a second? All in favor of the motion to carry over for the year, House Bill 304, vote aye. All opposed, no.
Ayes 14-0.
Ayes 14-0, good.
Thank you,
got
Mr.
another
Chairman.
one?
One more, House Bill 824.
Okay, ex parte.
Yes, sir. You passed, Mr. Chairman, you passed a very similar bill. There's Senator Morrissey's bill, which is Senate Bill 806, and I'm fine with conforming that bill.
Is there a motion to conform House Bill 824 to Senate Bill 806? Moved and seconded. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Is there a motion to report? It's been moved and seconded. No. House Bill 824, the substitute to House Bill 824. All in favor of that, is there a motion? And seconded, all in favor of the motion to report the substitute to House Bill 824, vote aye. All opposed, vote no. Okay,
Ayes 12, noes 2.
okay. 12 to 2.
Thank you, Mr. Chairman.
I'll share. Where- Well, anyway. Okay, oh, I didn't see, yeah, okay. You're coming up, we'll take your bill.
I have 4 bills.
Which 4 bills, okay. Delegate Watts.
Thank you very much, Mr. Chairman.
Which ones?
Going in numerical order, the first one is House Bill 251.
All right, House Bill 251.
And you have-
Constitution.
Thank you. You have seen this before, and however, it is significantly less than it started out several years ago. And it's very much targeted towards what Senator McClellan was talking about, the person who uses the services. So if you turn to page 4, you will see that it is now targeted just at, and I have lines 216. However, any adult who knows that a place is used for lewdness, assignation, or prostitution with a person under age 18 is guilty of a felony. So it's only if you visit. It's not if you're working in the place, which was not good language. It is at the suggestion of the Crime Commission. It involves persons under age 18, not just under age 16. In past years, it has dealt with those acts in vehicles and in other places. This deals only with places where there is a general reputation of being, the old-fashioned word, bawdy place.
Delegate, so just showing up is enough? Taking
You are
someone under
visiting
18?
a place that you know by general reputation is a place where, and again, law enforcement and all of the case history on this code section, it has only been enforced as prostitution. Law enforcement has never gone after a bawdy place as just a place of assignation
But you
or
don't have to do
lewdness.
anything but show up, is that it?
Yeah,
Just
so
showing
you
up.
know when you're there, why you're there. And so this then, as it was brought to me several years ago, goes after, as Senator McClellan observed, the people who are consuming the service, which is why the service is in fact provided, and it only goes after you reasonably knowing that someone under age 18 is employed there.
Well, suppose you're showing up to clean up the place.
Pardon?
You're showing up to, clean up the place, to sweep the floors or something like that. I mean, would that be covered?
Well, again, the case law on this, you have to know that there's a general reputation about the place being used for prostitution.
Suppose you're showing up to bring food or something. Senator Morrissey?
Delegate, directing your attention to lines 215 through 217. Need you to, what is a bawdy place? without using the word body in the definition.
Yes, and this is one that has been raised, and I think another bill, another year might modernize this long-standing reference to body place. It is a place, as you see there, of lewdness, assignation, or prostitution. There are case law that goes back decades on the word body place, and it's just something that has stayed in our statutes in part because of all the case law. But again, as I've gone back over the decades, it has only been prosecuted on prostitution, not on assignation or lewdness.
Follow-up question, Mr. Chair.
Senator.
On that same line, would you define lewdness?
Senator Morrissey, that is exactly what I was attempting to address. Case law, it is just not prosecuted as lewdness. I would suggest that that this be considered for future legislation to redefine what body place means, but the decades of history in case law, it includes lewdness as well as assignation.
Right. Further question.
Senator Morrissey.
When you were defining it earlier, Delegate, you kept referring to a body place where prostitution takes place. Here's how I'm going to read the statute, and any adult who visits a body place for lewdness is now a Class 6 felon. That's what the legislation says. Any adult who visits a body place that's used for lewdness is guilty of a Class 6 felony. It doesn't say visiting just a place of prostitution. It says lewdness. So before we can criminalize this, we got to know what body and lewd is.
Mr. Chairman, I would respond and again, I totally understand the concern, but before I change words in the statute that have decades and decades of case law, I do not feel that is appropriate. I hold to the two things. One, that in a prosecution under this section, the general reputation of the body place must be proved. And also, as I have mentioned, that I have found nowhere in case law where there has been any prosecution other than for prostitution.
All right. Then, Madam
more
Delegate Watts, how about we would you agree to take out the words lewdness and assignation on line 216? And just say, I'll get back to the body place in a moment, a body place that he knows is used or to be used for prostitution.
I have no problem with that.
Well, that's my motion then, right? Thank you, ma'am. Okay. I'm talking about staff on line 216. It says, visit a body place that he knows is used or to be used for lewdness, assignation, or prostitution. Delete the words lewdness, comma, assignation, comma, or.
And Mr. Chair, you'd also then need to delete those languages in the definition of body place
Yes.
on lines 219.
Yes, sir.
And
Okay. So you got two places.
the
go ahead.
concern that I have, Mr. Chairman, with that amendment is that it is preceded by the words as used in this code, body place means. And that's where I get into all the decades of case law on this. And that's where I think it goes beyond what this bill is all about. It is worthy of a separate bill, but I'm concerned about this bill going far beyond what its intent is.
Senator
Mr.
Boysko had a question.
I'll defer to the senator from.
Mr. Chairman, before we go towards an amendment, may I ask a question?
Yeah, let's do that. Senator Boysko, then Senator Stewart.
Thank
Delegate
you.
Watts.
I'm
sorry, go ahead.
My turn. Mr. Chairman, I was actually wondering if maybe council might give us the full definition to see if we're all having the same understanding so that we're not inadvertently criminalizing something that we don't intend to.
Yeah, counsel.
So, Mr. Chair, the definition of body place is on lines 218 to 219, and it says, as used in this code, body place means any place within or outside any building or structure that is used or to be used for lewdness, assignation, or prostitution.
And so, Mr. Chairman, that could include the parking lot of a place, and that may not be the patron's intent. That may sweep too broad, and so it may be consistent with the patron's intent that an amendment is made so that the new crime is when somebody enters a bawdy place. Otherwise, a person might be guilty of this new crime simply by walking through the parking lot of a bawdy place if he knows what's going on inside. And I don't think the patron means to capture that.
Yeah, Senator Stewart.
Mr. Chairman, and that is to my point exactly. If you pulled into the parking lot, you could be guilty of a Class 6 felony if you had knowledge of what's going on. But beyond that, you shouldn't be a felon unless you're engaged in some kind of activity.
Right.
And right here, this bill is just saying, if you just visit this place, which you shouldn't do, but you really ought to be engaged in some sort of criminal or nefarious activity before we make you a convicted felon.
And Mr. Chairman, Senator Stewart, perhaps if that were what the patron wished, you would reword it to criminalize any person who visits a bawdy place for the purpose of prostitution with a person under the age of 18 is guilty of a Class 6 felony.
Senator Deeds.
Mr. Chair, and this question was posed in other places, but it seems so relevant. What if a 19-year-old is being trafficked and a 17-year-old is being trafficked, and they're both in the same place and they're there for prostitution, and neither one of them is a trafficker? The 19-year-old is under this statute because the 19-year-old is in the place. The 19-year-old is subject to a felony prosecution and being placed on the sex offender registry.
Right. Yeah,
And Mr. Chairman, if I may respond and try to sort of, I'll respond first to Senator Deeds. This is why the bill as introduced was amended to only be visits a body's place because we did not want to include someone who resides in. The next point that I would make is that on line 213, you visit for immoral purposes. So that is up to the prosecution to be able to make the case that you visited for immoral purposes. And so without rewriting, again, my problem is with a very well-established statute, I'm concerned about rewriting its implications as to how it's applied otherwise.
Senator Boysko has a question.
Mr. Chairman, so not meaning to derail your bill, but I'm getting some concerns here. So I looked up, I'm not familiar with the term assignation, but when I look it up, an appointment to meet someone in secret typically made by lovers. So that would mean that.
We have taken that out, though, per the amendment that was just, it was the issue whether or not lines 219 and 220 was too broad.
I'm not aware that we actually passed that.
We haven't done that yet. Senator Deeds.
Mr. Chair, what worries me is what if the 19-year-old and the 17-year-old aren't living there? And they're just visiting, they're trafficked to a motel that is basically a bawdy place. It's used for prostitution, but they're not living there. They're just there for the evening, but they're being trafficked. They are basically victims of the offense, but the 19-year-old is subject to felony prosecution under this statute.
Yes.
Not under the wording of the amended bill before you, which only talks about the 19-year-old would have to be visiting there for immoral purposes as opposed to residing there, and therefore it's not applying to that.
But if she's just taken there for the night and she's taken there for prostitution, somebody else is taking her there for prostitution, she's not, and she's there for the night. She's not there for, not living there, not residing.
Yeah. Senator Morrissey.
We know what you're trying to get at, but here's the problem. It captures the following situation. Two lovers, 30 years old, go to a seedy motel for an assignation. They are now felons. They've gone to a bawdy place for the purpose of assignation, which was just defined as two people meeting in secret. It also makes it a felon for two lovers to go to that same seedy motel to engage in lewdness. God, I don't know exactly what it is, but my grandmother says it was a bad thing. So that's the problem, and you keep referring to the prostitution. Let's just say it, to go to a bawdy place to engage in prostitution. I just remember 3 words grandmother said: tawdry, okay, lewd, and this and bawdy. And I never quite knew what tawdry was, but I knew it wasn't a good thing. But those words capture legal activity, even though we may find it unseemly. But 2 consenting adults going to a bawdy place to engage in an illicit, to engage in an affair or an assignation is not a felony, but that we've just made it a felony.
Mr. Chairman, if I may respond, the first sentence of that code section, and I don't know how old this sentence is, says it's unlawful for any person to keep any bawdy place or to reside in or at or visit for immoral purposes. So any such bawdy place. So what you have posited has been against the law for as long as this statute has existed.
Mr. Chairman?
And I'm trying to go after just the John.
Yeah,
Mr. Chairman, there's a difference between unlawful and immoral. My Catholic priest would say, for those 2 adults to go to that hotel is immoral. But there's a difference between making it illegal. And so we've debated this enough, Mr. Chairman. I had an amendment. I thought the patron agreed to it, but I'll make the amendment and let's just vote it up or down. My amendment was to delete the words lewdness, comma, assignation, comma, and the word or, and just leave it to prostitution.
We just, as I recall, legalized fornication the other day, didn't we?
Yes.
So you want to... Not spitting. You can't spit.
But that fornication under this bill, which is assignation, that's now what not only did we make it legal last week, but now we made it a felony today.
So now what you're saying, just visiting a place that's used for prostitution by itself is illegal, just showing up.
I'm trying to help the patron. I just want to keep prostitution there. If you insist on, it's your bill, Delegate Watts, I'm just trying to help.
Well, take the amendment, and then if I could have the final word before the vote, I would, not on the amendment, but if I could have the final vote on the, final word before the vote on the bill.
You want to do this?
I made the motion
It's
for
been
the amendment.
moved to delete lewdness, assignation, or on line 116, and also in the definition of bawdy place, 219, remove lewdness, assignation, or just leave it as prostitution. So a bawdy place is the only place used for prostitution.
And Mr. Chair, what worries me about taking out established language in the code is what impact that's going to have on existing case law. I mean,
Mr. Chairman?
Senator Short.
Can I make a substitute motion?
Sure.
I have the greatest respect for Delegate Watson. I know what she's trying to do. I don't think we're going to be able to make this statute work this evening because we have a lot of other bills. So with all due respect,
carry over.
I would move that we carry it over for the year and maybe we can try to figure out the right language.
Okay, second. All in favor of the motion to carry it over for the year, vote aye. All opposed, vote no.
Mr. Chairman, could you, excuse me, thank you.
It's been carried over for the year by a vote of 14-0. Okay, next.
Okay, the next one in numerical order is 253.
Health Bill 253.
This,
offender crimes.
What this bill would do is that there are currently 4, it has to do with the sex offender registry. There are currently 4 misdemeanor offenses where a third or subsequent offense is, you are then put on the sex offender registry. And those are knowingly or intentionally creating an image where the person has reasonable expectation of privacy. as well as sexual battery, as well as third offense sexual abuse of a child, as well as third offense and attempt to commit sexual battery. So what this bill does is that it says the third offense of disseminating a image that is without a image of nudity, without the authority of the individual. 3 separate convictions of such dissemination would qualify for listing on the sexual offender registry.
Any questions? I'm trying to find out where in the bill, the only thing I see in the bill is 131.
Yes, it's on lines of 30, third or subsequent, and then 31 and 32 refer to this code reference that which would be the dissemination without authorization.
Mr. Chairman?
Yes,
Question
Senator
for
Boysko.
what, Delegate Watts, what is the current?
Pardon?
What is the current law under this?
The current law, it's a misdemeanor, and it's a repeated misdemeanor. And again, the dissemination, as it actually reads, is not just dissemination without authority, but it has to be proven that that dissemination was malicious with the intent to coerce, harass, or intimidate.
What is 18.2-386.2, Counsel? What's that one?
Mr. Chair, that is the statute that Delegate Watts just referenced. That's the unlawful dissemination or sale of images of another, commonly known as the kind of the revenge porn statute.
All right, okay, I got you. All right, any discussion about this bill? Okay, is there a motion? Yeah, it's been moved and seconded to report the bill. All in favor of the motion? And refer to finance. All in favor of the motion to report and re-refer, vote aye. All opposed, no.
1400.
Okay, that's 1400. Congratulations.
The next one in numerical order is 746. This has been worked on significantly, and it deals with the custodial interrogation of a child with focused on parental notification. Do you have the substitute before you? I assume. Right. Then I am merely pointing out that prior to any custodial interrogation, there has to be an attempt to reach the child's parent, guardian, legal custody, and before it shall be notified of the arrest. And then with B, you have a number of exceptions so that if the child has been arrested for or has been charged with or being investigated for a crime against that child, that would be an exception. Also, if the child's parent or guardian is the co-defendant in the alleged offense. Also, if there's been all reasonable effort to comply with the subsection and you can't reach the child's parent, guardian, or legal custodian. And then, of course, the fourth exception being that if law enforcement conducting the custodial interrogation reasonably believes that there's a need for the information to protect life or an emergency.
Anybody in favor of the bill? Here we go. Got some people in favor of the bill.
Chairman.
Yeah.
Senators John Mahoney, Virginia Association of Commonwealth Attorneys, and we support this bill. And speaking for Caroline County, this is the type of bill our parents want, and we appreciate the patron allowing us to
How do
work
you,
with
how do you
them.
enforce the bill? There's no enforcement mechanism. Suppose that happens, they have a custodial interrogation of a child without contacting the parents. Then what happens?
I'm sorry, sir.
Yeah. Suppose the police have a custodial interrogation of a child without contacting the parents of the child.
There'd be an issue for the judge.
I mean, does it mean the statement of the child is just?
It's gonna, I think it would be excluded.
Mr. Chairman, with all due respect to someone I have tremendous respect for, it would only be suppressed if it were unconstitutional. And beyond that, the statute does not provide that it would be inadmissible. And I think so, even if an officer acted in violation of this, that would not offend any constitutional provision, and hence it would not lead to suppression. So it would come into evidence. And, Mr. Chairman.
Perhaps it should come into evidence. Whether or not the judge would allow it is a different question, quite frankly.
That's right.
Okay, all right. Okay, next, is anything? Okay.
No, sir.
Somebody behind you? Okay.
Thank you.
Thank you so much, Mr. Chairman. James Dold, again for the record, representing Human Rights for Kids. We're very much in support of this bill. The original version of this bill did have an exclusionary provision so that when there was a violation, that evidence, any statements made by the child would have excluded it. Through that process, working with Delegate Watts, that was amended out of the bill to try to make it a smoother transition so that the law enforcement community could support the bill. But we would just say that this is a really important provision because both from a parental rights standpoint, if your 16-year-old child, for example, was arrested, I'm sure most people in the community would want to know, would want to be notified, and want to have contact with them at the time of the arrest. And so it's really important from both a parental rights standpoint, but also from a child rights standpoint to make sure that children at least have contact with their parents so they can talk them through the process, make sure they understand their constitutional rights. The only other thing that I would add, Mr. Chairman, is that this is actually something that's in line with what the American Psychological Association has also said should be in place to protect the constitutional rights of children. So it is a good first step to putting in place a system to protect the constitutional rights of children. Thank you.
But how do you enforce it? It's not enforceable.
Mr. Chairman,
Yeah.
it's not enforceable. It's aspirational, and I don't mean any harm to the bill. And I understand that the language that was in before did not make it over here. But make no mistake, it is aspirational. It's a directive that we don't currently have, that parents should be notified before their children are interrogated. And I know this is a concern because every time a parent calls me, they are aghast that an officer has been able to interrogate their child without notifying the parent. And so even though it may be aspirational, it is still, as you say, a step forward. I do have some technical amendments to suggest, however.
Okay.
When I read the bill, I wasn't sure, well, let me back up. The preceding sections, 16.1-246 and 247, describe at least 9 instances when a child can be taken into immediate custody. And not all of them contemplate a law enforcement officer taking a child into custody. And so I didn't know, Mr. Chairman, if the patron intended for that to be custodial interrogation by anybody of a child. What I suspect is that the patron intends it to be custodial interrogation by a law enforcement officer.
That was indeed the nature of the substitute.
What I would suggest as substitute language would make the bill read as follows. Prior to any custodial interrogation of a child by a law enforcement officer who has arrested that child pursuant to 16.1-246 subsection C, C1, and D, and those are the subsections that permit an officer to take somebody into custody for a criminal violation. And then the rest of the bill would read as it's written, and then there would be a sentence added, because my next question was, if you provide a requirement for notification, how is that notification supposed to take place? One suggestion, if the patron wishes, is that a sentence be added that says the notification and contact required by this subsection shall be in person, by telephone, or by video conference.
I'm a little hesitant because of all of the ways in which we reach out with emails, and I don't find that in what I just heard.
Shall be in person, electronically, by telephone, or by video conference. And I say that because otherwise an officer could put a notification in the mail and then proceed with the custodial interrogation. So I think the patron intended it to be ideally in person, or at least simultaneously, electronically, by telephone. So I would suggest those amendments.
Okay, by a law enforcement officer, and what else? Is that it? On line 12, line 11? So prior to a custodial interrogation of a child.
Of his arrest, prior to any custodial interrogation, that's beginning on line 11, of a child by a law enforcement officer who has arrested that child pursuant to 16.1-246C. That's when the officer observes a crime, a misdemeanor being committed in his presence. C1, That is for the arrest of individuals not in their presence, but it has specific crimes such as shoplifting. And then D, which is probable cause to believe that the child has committed a felony. And that is distinct from the other instances in the preceding sections where children can be taken into custody for such reasons as they have run away. And I think the patron would want an officer to be able to question a child about why they ran away to determine whether there's a problem with an abusive parent. And so that's why I limited it to situations where a law enforcement officer has effected an arrest pursuant to his specific powers in a preceding section.
Which are for felony only?
No, misdemeanors and felonies under differing circumstances.
Which crimes are these? We talking about shoplifting and things like that, or what?
Yes. Yes, you can, an officer under current law can arrest a child who commits a misdemeanor in his presence or a misdemeanor involving shoplifting, assault and battery, carrying a weapon on school property. Even if that's not committed in the officer's presence, he may arrest based upon probable cause.
So it's limited to that.
And two, probable cause to believe a child committed a felony.
Right.
And this would be in keeping with, actually on 12, where it said, shall be notified of his arrest. So I appreciate that clarification.
Okay. Is the motion, it's been moved, is there a motion that we adopt that amendment? Yes. Okay, is there a second? Okay. Any discussion? All in favor of the motion to adopt that amendment of Mr. Benjamin's, say aye. Aye. All opposed, no. Again, the enforcement part of it. Yes, Senator Morrissey.
I think I understand the amendment that Mr. Benjamin made. With regard to, where does that put us with regard to Section B, lines 14 through 22? Where are we there on, are those remaining?
Yes, Mr. Chairman, Senator Morrissey, those exceptions would remain.
Here's my problem, and maybe the patron can address it. We start off with a very strong position that prior to custodial interrogation of a child, the child's parent, guardian, or legal custodian shall be notified of the arrest, and the child shall have contact with his parent. Great. Very strong, unambiguous. And then the amendment was helpful, but now B, we start chipping away at that, and that concerns me. I don't know if it concerns anybody else on the panel. We start chipping away at that, and that's troublesome to me.
If I may respond,
okay.
the exceptions, and they each have their own reason for being, but the first one is the co-defendant. You don't want to notify I'm just going to use the word adult if we're talking about a co-defendant. The second one was if the child is the victim of the adult, you wouldn't want to notify the adult. The third one is the obvious, you make all efforts that you possibly can, and then you may proceed. And then the fourth one is also, I think, rather obvious, that if there is an emergency that you need to protect life or limb, that you can go ahead with the interrogation.
Mr. Chairman.
Yeah, Senator Morrissey.
Well, here's the first one. The child and the parent, one parent, are engaged in criminal activity, right? There's nothing prohibiting the police from contacting a custodial, another parent or guardian who is not a co-defendant. I get it. Doesn't even make sense to contact the co-defendant parent. But we still, if we agree with the language in Section A, 11 through 13, then just because that child has a co-conspirator or a co-defendant who happens to be a parent doesn't mean that, okay, now it's all right to question him. Second, line 4, that's a catch-all. If the law enforcement officer conducting the custodial interrogation reasonably believes the information sought is necessary to protect the life, limb, or property from an imminent danger. I don't know how you protect property. I guess I can think of a scenario from imminent danger. We are absolutely...
A bomb.
That would be how?
I'm
A
sorry?
bomb.
Is somebody talking?
Terrorism.
Right.
Who's talking?
I'm sorry, I thought
Okay.
we are
Oversharing.
chipping away from that. So I think we have to take a position, the committee does. Do we protect that child's rights by notifying a non-co-defendant parent? And if we do, then we don't need Section B. I may be the only one that's seeing it that way.
Okay. Any further questions? What about the exclusionary rule? You took that out in the House.
I'm sorry.
The exclusionary rule. You took that out in the House.
And I'm trying to reconstruct the argument for taking it out, and for the life of me, I can't. So I would think that if you made the amendment, if there's a strong reason that can be articulated in conference,
Mr.
that...
Chairman, I mean,
certainly, Senator McDougal.
Mr. Chairman, certainly you make it stronger if you put that in, but typically the exclusionary rule is for constitutional violations. And even though we are thinking that this is a good idea, it is not a constitutional violation.
Mr. Chairman.
You can put it back in, but I know a number of us will feel very strongly in a negative direction toward it if it is in the bill.
Mr. Chairman, Senator McDougal is correct when he identifies the addition of that language as potentially being problematic to passage. That's one consideration. But as to the exclusionary rule or making something inadmissible is something we do elsewhere in our statute. For example, if there's unlawful wire interception, that statute provides that evidence derived from unlawful wire intercepts is not admissible. Same too with the testimony of somebody who is compelled to give testimony against themselves. And so there's nothing wrong with providing for inadmissibility. But that still leaves the passage question, whether that would hurt the bill.
You could argue, well, it's involuntary, so anyway. Okay, if there's no motion on the exclusionary rule.
Move to report as it is.
Is there a motion to report as amended? Doesn't have to go anywhere, right?
Yeah.
All right, all in favor of the motion to report as amended, vote aye. Aye, all opposed, no.
Ayes 12, no, 0.
Ayes 12, no, 0, motion carries. Congratulations. Anything else?
I have one more. Now, this is actually the easiest, I think,
okay.
with all due respect to my colleagues. HB 1181.
1181. Okay.
And what this does is clarify when there's been a violation of a protective order, that venue can also be in the place where the protection order was issued and not where the violation, and not just where the violation occurred. So it sets up a situation where it can be either where it was issued or where the violation occurred.
That's not the law today? Steve or anybody? Staff?
Move to report, Mr. Chairman.
Mr. Chairman, is this necessary, I guess is my question.
Mr. Chairman, I just
Yes,
want
sir.
to,
McDougal?
I'm not saying it's a bad idea, but just want to point out a hypothetical. Violation is a protective order is taken out in Accomack County. Individuals move to other places in Virginia or out of state, and a violation allegedly occurs in Washington County. Now, you could either have the prosecution be in Washington or Accomack, and none of the parties might live in either place. So just...
I would have thought, frankly, that the court whose order is being violated is a contempt of court for one thing. I mean,
This was brought to me by the Property Law Center, and what it allows for is the determination from the person who, and I'm going to use the word victim, this is in domestic protective orders, that for the person to decide that perhaps back where it was ordered, that court is most familiar with the circumstances of the protective order.
I think it's a good idea, except that what facts gave rise to the bill?
Part of it is that sometimes if the violation happens, as in Senator McDougal's example, if it's much farther away from where the actual original protective order was issued, there's not all of the information about the conditions, et cetera, and the context of why the protective order was issued. So the evidence is not available
But there's no
to.
case that says you can't do it.
No, I think the point is you can't now. You can only bring them where the protective order violation happened, not where it was issued as well. So that's what we're adding.
Mr. Chairman, let me give you another hypothetical. If somebody alleges there was a contact at a Walmart in Washington County, the protective order was taken out in Accomack. If you want to get the custodian to introduce the video from Washington County, you're going to now have to move them from Washington to Accomack in order to introduce the video of that situation. So we are taking away from where the action actually occurred, which is typically where we cite
Well,
venue for criminal.
I think she's saying
Mr.
you
Chair
cannot
and
do it.
Senator you're giving Commonwealth attorneys choices.
Yeah.
You're adding a choice.
I thought they already had it. Yeah, go ahead.
If you just look on
Senator
line
Morrissey.
42, it says "or."
Yeah.
I'm sorry, the person testifying is accurate. It can be prosecuted in Accomack or Washington. Let the prosecutors sort it out, but I think it's common sense, Bill. We do this in other pieces, in other areas where a threat is made. Sometimes the threat can be made where the person makes the threat via telephone or where the threat was received. This is not novel or unique legislation, and I think it makes it easier to prosecute a
Is there a
violation of
motion?
this
It
protective
does clarify it. I think you can already do it like this, but it does clarify if you want to. Is there anybody? It's been moved and seconded to report House Bill 1181. All in favor of the motion, vote aye. All opposed, no. Okay, thank you. Okay. Delegate Bourne is, all right.
I will step into the line of fire.
Yeah, okay, go ahead.
All right, which one are we going to do first?
Up to you.
1627?
16.
Happy to do it. Mr. Chairman, members of the committee, House Bill 1627, I believe there are some amendments. Yes, it was,
Senate
yes,
Bill
absolutely.
997 identical? Okay, all right. Is there any, except mine was PBI'd, which is a terrible idea, but anyway.
Mr. Chair, there are 5 amendments. They all do the same thing. But in, I guess, response to the committee's questions about the venue statute, basically the amendment would provide that if venue cannot otherwise be established, it would be in the city of Richmond. And that is what the amendments do.
Okay. And the venue for what?
Prosecuting threats.
As I recall, Mr. Chair, this was your bill that related to threats against members of the General Assembly, the governor, governor-elect, lieutenant governor-elect, attorney general-elect, or members of the Supreme Court or Court of Appeals.
And I believe it also includes property here at the Capitol as well.
Okay.
Okay.
Mr. Chairman, could I ask the patron one question?
Yeah, go ahead.
Do you object to conforming this bill to the Senate bill that already went out of here?
No, it didn't.
No, it didn't pass here. That was the problem.
Didn't pass.
Makes sense.
It was, okay. All right, it's identical to my bill. Okay, is there a motion to report the bill?
Mr. Chairman.
Yeah,
I think you have to take up the amendments, but, Mr. Chairman, I just want to, we had this conversation before, but we are now putting elected officials in a different position than every other citizen in the Commonwealth. And I personally have some real concerns about that. There's no requirement that anything has to be related to the Commonwealth. If I'm an elected official, I'm close by. If Senator Chafin is the one that the threat's made against from Russell County, and he can't determine whether he was in Russell or Washington, they can bring the charge in the city of Richmond.
Mr. Chair, I would point out that looks like different language on lines 40 through 42 is in this bill, from your bill, and it says, and such official or employee was threatened while engaged in the performance of his public duties or because of his position. That probably, I don't think that language was in the Senate.
Here's an amendment.
Mr. Chair.
Go ahead, Senator McClellan.
So, Mr. Chair, just a reminder, this bill covers several different offenses, one of which is threats to a public official.
Mm-hmm.
And some of those public officials are in the seat of government, which is in Richmond. And some of these are threats against other individuals. And the problem this bill is trying to address is depending, if a threat is made through the internet or social media or an encrypted text program, you cannot always determine where it was sent from. And depending on where the person, if they receive it through an encrypted text message on their phone, you might not know where the person was when they received it, because they receive it when it shows up on their phone. They may not see it until later. So all this bill is doing is saying, now with the amendment, if you can't figure out where venue is, do it in the city of Richmond, which there are other offenses where we say venue is the city of Richmond, and it makes sense for someone who is a government official to do venue in the seat of government if you can't figure out where else to do it.
Okay, now these amendments would conform it to my bill, is that right?
No, Mr. Chair, as it came over from the House, it was identical to your bill because we adopted similar amendments to the amendments now. These new amendments are what provide that if venue cannot be established elsewhere, it would be in the city of Richmond.
Okay.
So with these amendments, it would be different than your bill.
Got it. We have five line amendments that all say venue cannot otherwise be established right? Okay. Is there a motion we adopt the line amendments?
I make that.
Second. All in favor of the motion say aye. Aye. The motion carries. Okay. The motion is made to report the bill as amended. Is there a second? Second. Anybody speak in favor or against?
Yeah.
Okay.
This bill is brought, as you know, Mr. Chairman, on behalf of the Capitol Police.
Capitol Police, okay. It's a good bill. Okay. All right, it's been moved and seconded that the bill pass as amended. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 10, noes 4.
It's 10-4. Congratulations. Glad you got it out.
I think you softened them up, Mr. Chairman.
Yeah, I did. I softened them up.
Which one do you want to do next?
Okay, which one do you want to do?
Whatever one comes up on the screen is fine with me.
Okay, which one? Let me see. All right, 11, House Bill 1499, Virginia Gun Violence Intervention Prevention Fund.
Sure.
And it's Senator Fevola's, similar to her bill.
Correct. This simply establishes the Gun Violence Intervention Prevention Fund and the Department of Criminal Justice Services. Monies in the funds are going to use to help localities administer gun violence and prevention programs in their communities. The governor's introduced budget had the money in there. I believe it's still in the House budget. And so I'd be happy to answer any questions.
Okay. Any questions? Been moved and seconded that what?
We want to conform it.
Huh?
Let's conform this bill to Senate Bill 248.
Is there a motion to conform House Bill 1499 to Senate Bill 248 of Senator Fevola's? Moved? Is it moved?
Moved, so moved.
And seconded? All in favor of the motion say aye. Aye. The motion carries. It's got to go to finance.
Okay, I moved to
It's got the
report.
clause, okay.
As amended.
It doesn't need, all right, it's been moved and seconded to report the substitute to House Bill 1499. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 11, noes 3.
11-3, the motion carries. Now we got House Bill 869, supplement.
869. Yes, sir, Mr. Chairman.
Compensation of public defenders.
Yes, sir. Mr. Chairman, members of the committee, 869 is a simple bill. It simply says if your locality has a public defender's office, but that same locality also provides a supplement to the Commonwealth's Attorney's Office, they need to provide a proportional supplement to the Public Defender's Office. As we know, our public defender's offices are woefully underfunded, and I believe that we can further our efforts to reform the criminal justice system by providing additional resources to the Public Defender's Office, who do great work defending indigent clients, making sure that justice is meted out in our system. So that's it. I know there's a lot of opposition from local governments, but I'd be happy to answer any questions you might have.
Okay, anybody want to speak in favor of the bill? We got somebody in favor of the bill.
Good evening, Mr. Chairman, members of the committee, Maria Jankowski, Virginia Indigent Defense Commission. This brilliant piece of legislation. I'm prepared to answer any questions anyone has and maybe dispel some of the rumors and concerns that people might have.
Is it in the budget? Where are we financially on this?
So, Mr. Chairman, this would not require, it does not require any state funding. And what you're going to hear probably from some of my friends that are standing up waiting to shoot arrows at this is that it's an unfunded mandate to our localities. But I would submit to you and the members of the committee that there couldn't be further from the truth. If you are, it might require you to spend your money a little differently than you are, but we're not requiring any new additional dollars. We're simply saying if you provide a supplement to your local Commonwealth's attorney, then you ought to provide a proportional one to the Public Defender's Office.
Okay. Is there any questions?
Can I ask, so you're suggesting that just take it from the Commonwealth's attorney and split it between the Commonwealth's attorney and the public defender?
Mr. Chairman, Senator Obenshain, I'm not suggesting to dictate how a locality might accomplish compliance with this bill. What I'm saying is how the locality spends its money, how they develop and how they work with the stakeholders to provide the proportional supplement is left to them. We're intentionally broad about that.
I was just trying to figure out the spending it differently part.
There's an estimate of local fiscal impact.
Mr. Chairman and Senator Obenshain, if I may, it's never been any of our offices' position that the money should come from the Commonwealth Attorney's budget. In fact, in the jurisdictions that have provided supplements, it's been a fraction of what has been given to the Commonwealth Attorney's Office. And in no way was the pitch or was the ask tied to a reduction in the funding to the Commonwealth Attorney's Office.
Okay, Senator Morrissey.
Question for the patron. The language, first of all, I acknowledge that it says if the locality elects to do that. So it's not, I agree with you, it's not a unfunded mandate. But let me just give you a practical situation and tell me how it would work, because I like the spirit of the bill. If a locality were to supplement the Commonwealth Attorney's Office to the tune of $100,000, are you saying, and normally the Commonwealth Attorney's Office can decide how to apportion that $100,000. Is your bill saying that the same locality shall supplement the Public Defender's Office to the tune of $100,000?
Mr. Chairman, Senator Morrissey, I would say no, because obviously there are probably different sizes and magnitudes of the Commonwealth's Attorney's Office versus the Public Defender's Office. So what this bill would do is make it proportional, and I think we leave it open to the localities to work with the Public Defender's Office and figure out what that right level is, and leave it to them to sort of work out the details. But it's not a dollar for dollar suggestion, or that's not the intent.
Okay. Yeah, no, let's step right. Huh? Yeah. I'm going to give 2 minutes each side, okay? Come on up.
Thank you, Mr. Chairman, members of the committee. I'll be brief. My name is Chris McDonald. I represent the Virginia Association of Counties. We do contend that this is an unfunded mandate. Our localities are currently in their budget processes now, and this will have an immediate direct impact on them. Secondly, this bill does disregard the difference between Commonwealth's attorneys and public defenders. Commonwealth's attorneys, as you know, are independently elected constitutional officers, while public defenders are state employees. Requiring local governments to fund these state employees sets a dangerous precedent going forward. And beyond the issue of this being an unfunded mandate or setting a dangerous precedent, legislation lacks clarity for how to properly address Commonwealth attorneys' offices and public defenders' offices that are shared by multiple localities. It lacks clarity on how to address supplements to positions that exist in one office but simply don't exist in the other. And again, with the July 1, 2020 effect, this will have a direct impact on localities' budgets. So I hate to be the one to shoot an arrow at this, as the delegate put it, because it is a really important question that he's raised and really important topic that we're discussing, but we do oppose.
Enrico, Commonwealth's attorney behind you.
Yes. Good afternoon, Mr. Chairman. Shannon Taylor, I'm the Commonwealth Attorney for Henrico County. I'm not speaking on behalf of VACA as association, but I am here to identify two things. Both Senator Morrissey and Delegate Simon had asked for the Commonwealth attorneys to look at their staffing standards, and I am the chair of that committee. It is my request that we carry over this matter to see how we are going to end up funding the Commonwealth attorneys. If we're talking about supplementing, it'd be good to know where we're starting from. Also to recognize, too, that when you have public defenders, there are conflicts, and who picks up that is the court-appointed. And we know we've heard Mr. Benjamin speak for many, many years that our court-appointed attorneys are grossly underfunded. So they're another piece of the pie that's not being looked. Overall, I totally appreciate my public defender colleagues. The piece of the pie is such that, but the pie has got to be bigger so that we do public safety the right way in the Commonwealth of Virginia. Thank you.
I believe Senator Benjamin says they're so underfunded they're ineffective. Is that right, Senator Benjamin? Okay.
Mr. Chairman, members of the committee, Ellen Villa on behalf of Fairfax County. We do have concerns about this bill as well. As many of you may know, in Fairfax, we do actually provide supplements to public defenders. This year, as part of our budget process, we're looking at doing more. Our concern with this bill is with the state mandate telling us how to spend local dollars to provide additional funding to the court system, which is underfunded.
All right, all of them who are having the same position, raise your hand. Okay, anybody who has a contrary position, come up and...
I do.
You don't, nobody has a
I have a
contrary
contrary
except for
position.
the delegate here?
I would just note, and I certainly thank my friend from Henrico for coming down, but I would note that this only applies to those localities who actually have a public defender's office.
Okay. All right. Colette, the Commonwealth Attorney of the City of Richmond that we're in right now has something she wants to say.
As the Commonwealth's Attorney for the City of Richmond, my name's Colette Wallace McKeechin. It's an honor to appear before all of you all, and I would second what the esteemed Honorable Commonwealth Attorney from Henrico says regarding the request to study this a little more, to let our staffing standards be reviewed, and to work in conjunction with the General Assembly and the Public Defender's Office to make sure that they are both appropriately funded, as they should be by a entity that was created by the General Assembly to protect the public welfare, but also recognizing that Commonwealth's attorneys have a number of statutory duties which you have imposed on us that are already in the statutes that are not imposed on the Public Defender's Office, that we are elected officials in the Constitution, whereas they are a statutorily created entity, and to second Shannon Taylor's statement that public defenders, if they are removed from a case because there is a conflict and they are unable to represent, the Commonwealth Attorney is not removed. And so the Commonwealth Attorney remains regardless of the public defender or the private criminal defense bar. So for all of those reasons and more, given the 2-minute time, I won't go into it, but I would ask that the General Assembly at least defer this bill.
Is there a motion that we pass
John,
this on
I mean,
to you?
Mr. Chairman, let me just make this, thank you, Mr. Chair. Let me make this point. It was at my behest that we continued over to the VACA staffing standards because I was concerned that staffing standards in Commonwealth Attorney's Office were influenced or determined by the number of prosecutions that were had or the number of charges that were leveled, and I agreed to carry it over. And I'm looking forward to that, to VACA doing their staffing standards analysis. This is a completely different animal. It has to do with inherent fairness. I haven't heard any public defenders yet, but let's be clear. The public defenders are paid less and sometimes substantially less than their colleagues on the other side of the aisle, the prosecutors. This bill is simply saying that we're going to have more equality, more parity, and I'm a little bit surprised that any prosecutor would oppose that.
All right, is there a motion?
I have a motion, Mr. Chair, to report the bill.
And I've got a substitute motion, Mr. Chair.
Is there a second to the motion to report?
I've got a substitute motion. That's
I don't hear a second, so, okay.
Second.
Oh, second, okay.
okay. Substitute
Senator
motion to
Dees.
carry the bill over for the year.
All right, any discussion on the motion to carry over for the year? This is a big issue. I agree with you. We need to do something about it. I'm not sure this bill does it.
Mr. Chair, I want to fund public defenders' offices. I want to raise pay for court-appointed lawyers. I think we all are invested. We've got to make sure that people that are on the front lines representing the accused are as competent as possible and as fairly compensated as possible so they can do as good a job as possible so we don't have any habeas cases down the road. The system depends on competent representation, but this is an unfunded mandate, and I don't know how we address that. And I think if we were doing a study on the staffing standards for the Commonwealth Attorney's Office, maybe at the same time we can take a look at coming up with a better way for the state to do its share for doing a better job of funding public defenders.
Mr. Chairman?
Yeah, Senator McDougall.
Can I also add in addition to that, the clerks are also key to make sure the orders are correct, because the attorneys can do all the right things, judge can do the right thing, but if the order is not correct, that is the record forever. And so when we have this conversation, I think we all agree it needs to be as a group, but the clerks cannot be left out of that conversation as well to make sure that that part of the process is done accurately.
And
Okay.
Mr. Chairman, just if I might, just very briefly, and I don't disagree with much of what's been said up at the dais, but I would say this, that I don't think that the two are mutually exclusive. The state investing more in the public defender's office is not mutually exclusive to the idea that if a locality is going to prioritize the prosecution of its residents enough to spend more money and supplement salaries of prosecutors, then we ought to care enough about the carriage or miscarriage of justice to also supplement in a proportional way the defense of people who have no other option than a public defender's office. Right. And so I understand where the bill is going. I understand what's going to happen to it. And I would hope that everybody that came up to oppose the bill would be just as supportive and lobby their local governments to invest more in the public defender's office, given the fact that it was referenced that we're in budget time.
Yeah, I agree with you completely. All right, is there all in favor of the motion to carry it over for the year? Vote aye. All opposed, no. Motion to continue. All right.
Ayes 8, noes 5.
8-5. See you next year.
Thank you. Well, I'm not done yet.
I know, okay. The other one you have,
I'm sure some of the same folks will be behind me in a minute.
Discovery?
Mr. Chair?
Can we,
Mr. Chair?
Is this next, wait just a minute, is this the next bill you have is?
Mr. Chair?
869, 873, the Discovery one?
Yes, sir.
Can we carry that over the week? I mean, this is going to take a while to
Mr. Chair?
do this, yeah.
Can you request that VECA, who is doing that staffing standards, report back to the chair of Senate Judiciary their analysis or their conclusion so that we have that next year?
Didn't we have another bill on that?
Yeah, I gave you one,
yeah.
and that was to report to you the
Yeah.
staffing standards of the Commonwealth Attorney's Office. We heard from several prosecutors that they want to study it,
Yeah,
and we want to get a report back from them.
right, okay, yeah.
Mr. Chairman,
I'll draft a letter
Yeah,
for you.
draft letter, okay.
Mr. Chairman, did I hear you correctly say that we were going to carry this over for
Discovery,
the
I
week?
think it's going to be a little involved.
That's fine.
Mine, we carried over for the year. Want to do that?
Carried over for the year. I do want to make the argument, so.
Okay, well, all right.
We can do it. I'm happy to move on since it's going to be a
Yeah,
longer
let's carry it
discussion.
over. We'll carry it over to the next meeting.
Okay.
Pass about, without objection, pass about for the day.
Thank you, sir.
Okay.
I don't think I have anything else.
Mr.
Okay,
Chairman,
yeah,
Is that it for me?
I have a question.
yeah, Senator Norman?
I noticed as I looked down to my right and in front of me that there are quite a few senators that are not here.
A lot of senators aren't here.
Not here.
but- Right.
Do we know that all of them are on the building or on Capitol Square?
I don't know.
Because we had a situation before where proxy votes were being cast while people were in restaurants.
I don't know where they are, do you?
It makes a huge difference, Mr. Chairman.
I agree with you.
Mr. Chair, Senator Peterson's absent, so
No, I
nobody
know
should be
that.
voting his proxy. I don't have any proxies myself, but I think that Senators Lucas and Servell are in committees, they're in House committees. I don't know about, yeah.
I
don't
have
know about Senator
Saslow's,
Saslaw.
and I think Saslow's around here somewhere. isn't he? I think he is.
Is that right?
He's went where? Huh? I don't know. All right, let's see. I'm gonna go down to this. Delegate Brewer. Okay.
So good to finally see you, Mr. Chairman.
Okay.
HB 557?
HB 557.
So we're going with first. I have two.
Okay, 557. Okay, carnal knowledge.
Yes. Mr. Chairman, this is a bill that Senate courts actually saw, I believe, 2 years ago. And I believe maybe you were carrying a similar bill, or the same bill possibly. This bill would increase to a Class 6 felony from a Class 1 misdemeanor. Anyone in the Bail Bondsman Committee that carnally knows someone under their direct supervision. This actually stems out of a case that was prosecuted regionally where the person is currently imprisoned for basically bonding.
Yeah, Senator
Do you think, if I recall this correctly, we reported this and we referred it to finance 2 years ago? It was all about finances, not the policy, and I so move.
Okay, the increases from Class 1 misdemeanor to Class 6 felony, right? Okay. It's been moved and seconded to report and re-refer to finance. All in favor of the motion, vote aye. All opposed, no. Motion carries. That was simple, wasn't it? Congratulations.
Thank you, Mr. Chairman. House Bill 1614.
All right, we've got to report it first. It's 12-0, the motion carries, okay. And re-refer, report and re-refer. Okay, the next one? Where? Okay, all right, they're in the building. Yeah, they're all in the building. Okay, the next bill is what?
House Bill 1614.
1614, House Bill 1614, and that is victims of human trafficking, right?
Yes, sir.
Okay,
Let me know when you're ready.
go ahead. No, go ahead.
So House Bill 1614 is to provide an affirmative defense for victims of human trafficking, like 29 other states across our country do. We had a lively discussion in House courts, and so we pared down this bill pretty greatly, and we only tied it down to 18.2-346 and 347, which is body, place, and prostitution directly. And so I hope with the will of this committee, if you have any questions, be glad to take them. But I hope
Okay.
the will of this committee to report the bill.
Okay, any questions? Staff, any comments? Okay, Steve?
Just the observation, Mr. Chairman, that this provides an affirmative defense for someone who's been coerced through the use of force or intimidation, thereby excluding those who have been coerced into prostitution through other means. For example, they become addicted to drugs, and their person who runs them is providing them with drugs. That may be the patron's intent, and sometimes it's better to have a more narrow bill than not. But there are categories of those who may be equally deserving of this affirmative defense who are not picked up by this bill.
Haven't we had bills like this in the past? It seems to me we have, because the issues on trafficking is you're right, it's not just force and intimidation, it could be other reasons. Any questions about that? Steve, you have a amendment or anything? How about anybody want to speak in favor? Anybody want to speak against the bill? All right, anybody on the staff want to say something? Huh? Yeah. All right, is there a motion?
Vaca didn't take a position on the bill, if you're asking.
Okay. I mean, defense is a good defense, but Steve raised the question, is it broad enough, right?
I'll move to report.
Okay.
Good beginning.
It's been moved and seconded to report House Bill 1614. All in favor of the motion, vote aye. All opposed, no. Motion carries. Okay, good.
Thank you, Mr. Chair, members of the
very
committee.
much.
Have a good evening.
Okay. Now, Delegate Byron.
This has been an exciting afternoon, let me tell you.
I'm sure it has been.
Mr. Chairman, it was 20 years ago, actually, that I came before this committee when Operation Blue Ridge Thunder started their work with internet crimes against children. And I'm back to you today to help with some of the prosecution of those cases. What this bill does, House Bill 1330, is create a new venue for the production, publication, sale, financing of child pornography. Unlike 20 years ago when you used your computer and everything was stored, a lot of things were stored on a hard drive. Today, they're being stored in the cloud, and you're using your phone and other mechanisms to produce and store pornography. So this bill would help with the prosecution of that by having another venue for where the information is stored. Right now, part of the problem is most of the crimes that are involved, they have to go to the internet provider, they flag an image, and they send the IP to the task force, and the task force gets a subpoena for the IP. Once they get that back, they investigate and get a search warrant at that point. It takes weeks to set up that investigation, and most of the cases now, since they're done on cell phones and stored in the cloud, proving where the phone was when it was downloaded or reproduced is exceedingly difficult. So this creates a venue that is already a venue provision that exists in the code. It doesn't make it any broader. The Commonwealth's attorneys support it. I believe they're here if you need to hear from them.
House Bill 1330, child pornography, possession, et cetera, okay? Anybody speak in favor of the bill?
Mr. Chairman?
Yes, Senator
I'd say
McDougal.
At least this venue section is where the defendant is, or where the act is. So it does have some nexus to that direction and not just in the city of Richmond.
Right.
So we'll move to report unless somebody's got a different opinion.
You got a Commonwealth attorney here who likes the bill, right?
We do.
Okay. Anybody opposed to the bill?
Thank
All right, is there a motion? Moved and second to report House Bill 1330 of Delegate Byron. All in favor of the motion, all in support of the bill of motion, vote aye. All opposed, vote no.
Thank you very much.
Okay, thank you very much. Okay, yeah, okay, yeah, yeah. I got it, yeah. Morrissey? All right, okay, the motion carries. Heretic, Delegate Heretic, okay.
Thank you, Mr. Chairman. Was it something I said?
No, it wasn't anything you said.
Mr. Chairman, House Bill 1581, very briefly, simply statutorily transfers the responsibility for maintaining official records for tax delinquent properties from the clerk of the circuit.
What's the bill number again?
I'm sorry, 1581.
1581, okay.
and again, simply transfers the statutory responsibility for maintaining official records of tax delinquent properties and maintaining and correcting those records from the clerk of the circuit court to the treasurers of the locality, and this comes at the request of the Treasurers Association. That's the bill.
Okay. Is there anybody in favor or anybody against? Okay, you're in favor.
Mr. Chairman, Alan Albert on behalf of the Treasurers. This was put in at our request. It simply conforms the statute to practice.
Okay. Is there a motion? It's been moved and seconded that House Bill 1581 be reported. All in favor of the motion, vote aye. All opposed, vote no.
Thanks, Senators.
Okay.
That's 13-0.
Okay. Delegate Simon? Is here? Okay. Delegate Simon. Foy? Okay. Delegate Foy.
Thank you, Mr. Chairman, members of the committee. House Bill 1324, Juvenile Domestic Relations Intake Procedures. So what this bill does is it's a recommendation from the Department of Juvenile Justice, and it's backed by the Northam administration. For almost every other offense that a juvenile commits, there is a 120-day diversion period, meaning that an intake officer has 120 days to divert that child in order for them to become compliant with whatever conditions they have to meet, except for truancy. Truancy, there's a 90-day limit. And the issue is that many intake officers are complaining that 90 days is not enough time to develop a truancy plan and ensure that the child will be and can be compliant. So the request is that the 90 days be extended to 120 days to align with all the other offenses for a child to be diverted before the complaint is taken up. And so that's what this bill does.
Okay.
Mr. Chairman?
Is there any, Senator McDougal?
Mr. Chairman, can you tell me, it looks like we added in possession of alcohol toward the end. I don't have the line number. What was that doing?
Yes, I believe the addition for alcohol, like other offenses, you can divert possession of marijuana, and if a child is in possession of alcohol, that can also be diverted.
Okay. Is any?
Is that right?
Is that right?
That's right, Mr. Chairman. Basically, it just makes underage alcohol the same as marijuana.
Is there anybody speaking in favor of the bill? Anybody? Here we go. Somebody wants to come up?
Mr. Chairman, members of the committee, I'm Valerie Boykin, Director, Virginia Department of Juvenile Justice. We support the bill.
Okay. Anybody against the bill? Is there a motion? Been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no.
Thank you, Mr. Chairman.
14-0. Congratulations.
Thank you, members of the committee.
Okay. Ken Plum, okay. Delegate Plum.
Thank you.
There he is.
Thank you, Mr. Chairman, members of the committee. I have House Bill 618 related to hate crimes. And Mr. Chairman, members of the committee, it's my understanding that you had a bill from Senator Favola earlier, and if you would conform the bills.
Is there a motion we conform the bill to Senator Favola's bill? Is there a second? All in favor? All in favor of the motion to conform, say aye. All opposed, no. Is moved and seconded to report the substitute to the bill. Is that right? It's a substitute. Yeah, okay. House Bill 618. All in favor of the motion to report the substitute to House Bill 618, vote aye. All opposed, vote no. Senator Norman? Senator Morrison?
Ayes 8, noes 5.
Ayes 8, noes 5. The bill passes.
Thank you, Mr. Chairman, members of the committee.
Is reported. Okay, thank you. Marius, yeah. Delegate Marius.
Byron's not in the area.
Marius. Okay. Which bill is this?
Mr. Chairman, I have two bills, HB 610 and HB 1096.
610. Okay. HB 610, limitations period. Okay, sexual abuse, 2-year period limitations. Okay. Tell us about the bill.
Mr. Chairman, this dates back to the Attorney General's report in Pennsylvania after the Catholic abuse scandal. About 15 states have, when individual victims have been time barred for actions, about 15 states have instituted this. 8 of them have given what have been kind of instituted as these kind of windows of time, 2 years, 3 years. I picked 2 years that allow people that have been time barred to have a 2-year period to file such a claim. Some states have just gotten rid of all statute of limitations on civil actions. That was, I think, looked at Boyd Graves and not recommended for Virginia. So this is a 2 years, a 2-year window, very similar to what several other states have done. Arizona has done 2 years. New Jersey has done 2 years. California has done 3 years. That allow those victims that have been obviously victim. It does not necessarily have to deal with the Catholic Church, but what happened in Pennsylvania was the Attorney General, the grand jury did an extensive investigation, and they listed a series of recommendations for how to deal with this in Pennsylvania. They had a very similar provision, and one of their recommendations was either have a small window of people that are time bar or get rid of the statute of limitations. And so this is a more narrowly drawn bill than what was done previously to allow a 2-year window and to move forward for those who are
We did the 20 years several years ago here in Virginia. Now, this bill, didn't we have a similar bill previously?
Mr. Chairman, the bill that we had on Monday was to apply the 20-year statute of limitations to actions against adults.
Okay.
Delegate Mears' bill provides basically a 2-year look-back window so that if the statute of limitations for a juvenile has already expired, they have 2 years in which that they could file.
Okay. All right. Any questions?
Yeah, just so
Senator
I understand
Obenshain.
it. So if, I mean, it's a 60-year-old.
Correct.
And the statute expired when he was 20 years old. This would revive it for 2 years?
For a 2-year window, they have a 2-year window to file. And that was one, again, kind of looking at what other states have done, and that's what several states have done to try to tackle this, because these stories are coming out, people that have essentially not come forward that have suffered some pretty horrific abuse. So this allows them. And as you all know, we don't have a statute of limitation on criminal felonies in Virginia, but this is for civil actions and allows that 2-year window.
Okay. Steve, anything?
Well, I'll just note that this is not a hypothetical. Excuse me. I recently had to defend an 80-year-old gentleman who was accused of sexual assaults that were said to have occurred 40 years ago by a young person who at the time had reported to police but did not want to go forward. 40 years passes. The 80-year-old is now suffering from dementia and is indicted because the former person is now 40 or 45, and it was almost impossible to defend. We have no statute of limitations for felony cases, but a policy consideration for the committee is whether there should be one that could permit an 80-year-old person with dementia to be sued after 40 years.
You're allowed to
Go
respond.
ahead. Yeah, if you want to.
I think one thing we also have to determine as a policy issue is we don't want to have happen in Virginia what has happened in so many other states have looked at what happened in Pennsylvania, in which there's a horrific, systematic, widespread area of abuse that has occurred. And then people wonder, well, why did other states tackle this, allow these windows of opportunities, and then Virginia had the opportunity not to do it? So I think it creates a window. It's not permanent, but I think it does enable and gives a avenue for victims of abuse to move forward for, again, on a civil action.
Mr. Chairman, Steve expresses concerns as Senator Peterson and I have both expressed over the years. I mean, the guilty guy, I do not care. I mean, you can put him under the jail, you can take everything he's got, I don't care. It's fine with me. It's the innocent person that I think Steve is talking about and who raises concerns for Chap and me. is how do they get due process? How do they protect themselves? How do they defend themselves when perhaps this is a, softball coach or baseball coach, and 40 years later, it's impossible to find, the kids or parents. They may be dead, gone, moved, records are gone, and it winds up being a very sympathetic alleged victim and a very, unsympathetic, defendant in the civil case. Maybe somebody who's had other troubles, substance abuse troubles, but is innocent. I mean, did not do it. I have a hard time seeing how that person can possibly get a fair trial.
I think on the other side, though, I mean, I have great faith as an attorney, Senator, in our civil system. And we have it set up so that individuals that have been wronged can seek civil remedies. And I think it is unfortunate that if you've dealt with those that have been the victims of sexual abuse, oftentimes just the trauma and just the fear, doesn't mean they don't feel comfortable really addressing this until sometimes they're in their middle age years. And then if they go to counsel, and they literally are time barred and they're not allowed to move forward. And I think that is a very valid concern, but I think that is an equal concern is that they are blocked from even instituting and finding a civil justice in this case.
Tough issue, and I agonize over it.
I think I remember we went through all this several years ago when we made it 20 years. But the question, and so if it's a juvenile, is 20 years for the statute of limitations to run. But in this case, suppose it happened 50 years ago, and now you get 2 more years. I mean, you don't have a beginning time at all. That's the problem I think Steve Benjamin's raising. There's no beginning time. Just starting now, you got 2 more years, but it happened 50 years ago. That's the problem, I think, the legal problem.
But if you were abused as a 6-year-old and you're 56 years old, why? I guess my rejoinder to that would be, and you finally, through therapy and through honesty and through loved ones, feel comfortable to face your accuser. I also don't think that you should be time barred either. And we're giving a 2-year window. It's not permanent.
Well, we discussed all that, and we came up with a 20-year period. Senator Deeds?
But in the case you just described, who would you be suing 50 years later?
I'm sorry, sir?
Who would you be suing 50 years later? You can't sue, you can only sue, I think, real persons. I mean, it's unconstitutional to sue retroactively. It's unconstitutional to sue other people that aren't natural persons.
Okay, well, if you want to make it, to your point, 30 years. I mean, I think our court system is effective enough to be able to weed through them. But, I mean, clearly it's the sentiment of the committee. I have an idea where this vote's going to go, but.
Okay. Is there any further discussion or a motion or anything?
I move that we carry the bill over for the year. Take a
Okay.
look at it.
Second. Motion to carry it over for the year. All in favor of the motion, vote aye. All opposed, no. Okay, thank you very much.
One other.
Okay, I got one more?
Yes, sir.
10-3. All right, carry it over for the year. All right.
HB 1096 makes it a class 1 misdemeanor for anyone to willfully or maliciously place a dead animal on any church or church property. The basis of this was a series of ministers that came to me that had non-domesticated animals. I'm not going to show the committee the photos, but rats with their hearts ripped out placed on top, headless rabbits placed on the doorsteps of the churches, always early morning Sunday, right before parishioners would show up. Multiple ministers came to me, and unfortunately the police said there's really nothing here. These are not domesticated animals, so they have to willfully and maliciously do so. In a couple other states, people have left dead pigs, mutilated pigs on the steps of mosque, which is offensive as well. So this was a problem back in my, I'd say still a problem in our neck of the woods. And so that is the basis of HB 1096.
Okay. Any questions?
I'm just wondering, I live way out in the country, Mr. Chair, and there are churches along highways, and, the deer get killed just about every night out in the highway. And if a VDOT guy is getting a carcass from the road and placing it on church property temporarily until he can get a truck, or somebody places on church property until VDOT gets there, have they, because the statute says willfully or maliciously, they willfully put it on church property. I would be more comfortable if it was just a malicious placement on church property.
I would be comfortable with that language
make
added.
sense?
That would not bother me at all, Mr. Chair, for Mr. Senator.
Yeah, Senator Boysko?
I just agree. I would move that amendment.
Okay.
Okay, is there a second? All in favor of the amendment to make it malicious only? That would mean we would strike, would add.
It's up on line 12. You would strike the word willfully or, and you just say maliciously. Okay.
Correct.
Okay.
Well, where would you put it? I mean.
22, perhaps?
Maliciously places any dead animal.
Well, the trouble is you got any person willfully or maliciously does a bunch of things, 1, 2, 3, 4, and this would be 4.
Well,
So
Mr.
we'd
Chairman,
have to have a new section maybe?
I would just create a new subsection B and make the existing B, C, and the existing C, D, but essentially the new B would be any person who maliciously places any dead animal with any church or church property is guilty of a Class 1 misdemeanor.
Okay. Is there a second, moved and second, all in favor of the motion? The line amendment, say aye. Aye, all opposed, no. Motion carries. It's been moved and seconded that the substitute be reported. All in favor of the motion, vote aye. All opposed, no. Okay, motion carries.
Thank you, Mr. Chair.
Okay. Delegate Simon?
Thank you, Mr. Chairman. My colleagues in the House version of this committee will be glad to have me back, I think. Well, some of them will anyway.
I'm sure.
Mr. Chairman, House Bill 623, you may remember this bill. This was a product actually of the Code Commission. About 2016, I think Governor McAuliffe introduced HB 1600 and then asked us to send it to the Code, General Assembly sent it to the Code Commission to look at all the gender-specific references in light of a Bergerfeld decision and take out all those as appropriate. The Code Commission actually convened a number of different work groups with different family laws, different sections of the bar to go through here to make sure there weren't any unintended consequences in changing these gender-specific references and that they were all intentional and not, they wouldn't have any unintended consequences. The product that came out was sort of endorsed by the Code Commission, but not a Code Commission product because of I think the partisan makeup and the sort of political nature of this particular issue. But I just want you all to understand the background. That's where the work came from.
Mr. Chair, my only question is for staff. My understanding is this contains elements of 3 different Senate bills, 17, 247, and 433 that I think I've already passed out of this committee and out of the Senate. And I wonder if there are other things this bill covers that those bills didn't cover?
Yes, Mr. Chairman,
Okay,
and Senator
what are those other differences?
The majority of the bill is different. The only parts that are the same, Senator Evans' Senate Bill 17 was the repeal of the ban on same-sex marriage and civil unions. That is identical in both the bills.
And that's contained in this bill?
Yes, sir.
Okay.
Senate Bill 247, which was Senator Sturville's bill about gender-neutral terminology and no-fault divorces, that is one section in this bill. It's on page 6. The terminology is a little bit different. In Senator Sturville's bill, we struck husband and wife and replaced it with parties to the marriage. In Delegate Simon's bill, he uses the term they. There's not a...
Mr. Chairman, so for what it's worth, Senator Sturville in courts the other day accepted my terminology and conformed his bill to mine, and we consider that a friendly amendment when that happened.
Okay.
And then the last portion that is different is Senator Sturville's bill, Senate Bill 433, was the repeal of the crime of adultery, changed it to a civil penalty, which we then changed to repeal 8.01- 223.1, and Delegate Simon's bill repeals the crime of adultery. So that is the one difference that the committee would need to consider and determine what to do with.
The crime of adultery, that's a separate issue we've done. We changed it to say that the adverse inference could be drawn if somebody pleads the fifth.
Mr. Chairman, I understand that rather than get this bill mucked up with that, I think it's a pretty easy fix to delete the reference to repeal adultery. I think you guys have had some serious policy discussions, and again, this is meant to be mostly a cleanup bill, so to the extent this is a policy decision you've elected not to make,
I'll
I
make a
consider that
motion, we take that part out of the bill, the adultery part out of the bill.
The other thing is the Code Commission is continuing to look at this issue. A bunch of things have already been done, as you know, but I believe, since I'm chairman of the Code Commission, we're still looking at, Go ahead. Kristen?
Mr. Chairman, if my understanding is correct, this is what the code was presented to the Code Commission 3 years ago, I think. And we've seen this bill or a version of this bill before.
Mr. Chairman, I would say that this bill's gotten a little skinnier over the years as we have taken some of these things on. Last year, you all did the surrogacy section, Delegate Sullivan's bill, dealt with a lot of the surrogacy issues in the gender-specific terms, so that's out of this bill now. So that as we've taken a little bit of it up piecemeal over the years that have come out, but again, this has been fairly thoroughly looked at by the Code Commission. I think that this just sort of finishes the job on that.
Well, that's what I'm trying to find out. I know we're continuing to look at some issues that are not as easy as you might think, because some bills, some laws need to have an he or she because it wouldn't fit otherwise.
And Mr. Chairman, I believe that the ones that are contained in this bill were the ones that everybody agreed were not problematic.
Okay, all right.
Well, again, Mr. Chair, I'd move to take out the language regarding the adultery.
Yeah, is there, and is that the only one, Kristen, that we?
Yes.
Yeah, okay. Motion's been made and seconded that we take out the adultery issue. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Kristen, is this pretty, Charles, is this okay?
Mr. Chairman, I'll be honest, the last time I looked at this was 3 years ago in depth when I drafted it then. It looks the same as it did, except as Delegate Simon said, it's skinnier than it was back then. So I don't see any other problems with it.
Okay. It's been moved and seconded to report the bill as amended and refer to finance. Okay. It's McDougal.
When we took the adultery after we changed it, we removed the fiscal and finance.
No. Yeah, Senator McDougal, anything else? No. Yeah, okay. Been moved and seconded the bill as amended be reported and re-referred to finance. House Bill 623. All in favor of the motion, vote aye. All opposed, no. Okay. Thank you.
Thank you, Mr. Chairman. Thank you, members of the committee. Thank you.
I gotta go to a couple of bills. Why don't you take it over? Who's next? Yeah. You want to go to 9 o'clock like usual? No. No. How many more bills do we have? Okay. How many more bills do we have here? 50? Okay. 15? 15? Yeah. Okay. Delegate Leftwich is next, I believe. Can you go ahead and take that?
I'll take it.
I've got, I tell you what, I'll grab my proxy. Huh? Oh, Kathy? Where's Kathy? Oh, yeah, come on up, Kathy. Kathy Tran.
I'll move out of your way.
What's she got? Tell you what, I'm gonna give you mine.
Good evening, Mr. Chair and members of the committee. I have House Bill 1222.
House Bill 1222. Turn your attention to the delegate. And as the new chair, I will tell you only 2 bills will pass. Everybody that wants to stick around, you're welcome to. But after 2, we're going to kill all the bills. Okay. No pressure.
All right, well, I hope I make the threshold. So this bill allows individuals who are living in nursing homes or assisted living facilities to be able to use identification that has expired for 5 years or less to notarize their documents if they don't have current ID. And so those identifications would be their licenses or state-issued identification cards and expired passports. Individuals, who are older or have a disability still need to sign documents such as a power of attorney or a medical directives, trusts, and wills, and sometimes they have to complete real estate transactions to help pay for their care. And so oftentimes they've let their, driver's licenses expire because they may not be in a position or have a need to drive anymore. And so this was just really help them be able to get their documents signed.
And the only question I have is, why is this limited? It sounds like it's for people that are having trouble, but what if they're living at home with some family members? Why is this limited to assisted living facilities and nursing homes?
It's an excellent question, Senator Deeds. And when we drafted, it came up in my subcommittee hearing in the House as well. And at that time, we just couldn't really wrap our arms around a way to define the rest of situations people might be in.
Mr. Chair,
Senator McClellan.
I think if you have someone who is in a nursing home or assisted living facility, it's a lot easier to verify that they are who they say they are and that it's not a fake expired ID. Whereas if someone really wanted to be creative and fraudulent out, at home, they could be.
We'll see. Well, I think we've been making some effort to try to.
Well, Mr. Chairman, the amendment that I had discussed with Senator Edwards was just making it apply to everyone. Now, that would not solve Senator McClellan's problem, but there are many reasons that people might decide that they don't drive anymore and not have a valid current driver's license. So the amendment would just strike the language related to people living in assisted living facilities or nursing homes.
So there's 3 no's for that. How do you all feel about that?
So I think I think there were some other concerns that were raised in the House by making it too broad. And so we thought in our subcommittee hearing that at least this would give these particular individuals some relief, and then we can go back next year and think about how to address the rest of the population.
Report as it is.
Okay, motion. Any further discussion? If not, open the roll. Okay.
Thank you so much.
Congratulations.
Thank you.
Okay, Senator, Delegate Leftwich was the next one. Okay,
Yes,
that's
sir.
one bill.
Thank you. And so if you're going to pass 2 bills and I don't have to say anything, I just say it's House Bill 1563 and, no, seriously. This is the emergency shelter bill. Probably seen some iterations of this in years past.
It's no different than the one we saw last year? Or?
Actually, it's improved. Okay. The language is a little bit different. This bill states that as soon as practicable after entry into the shelter, they shall notify staff. And then paragraph C is kind of new, and that was created in conversation with the governor's office, which would allow local localities.
Do you know if paragraph C was included in the Senate Bill 55, the Cosgrove bill that was introduced this year?
I do not believe, I'm not sure.
Okay.
That was inserted based on request of the governor's office.
Okay.
So.
The staff note, was that, the notes I have indicate that Senate Bill 55 was identical to this, but I don't know.
There was a substitute.
Right, Mr. Chair, subsection C is new to the bill. As introduced, it was identical to Senator Cosgrove's bill, but as the substitute, the paragraph, subsection C is new to this.
Okay.
Mr. Chair, to answer Senator McClellan's question, this bill is a little bit different than the bill last year. Last year, there was a bill dealing with this. Eventually, the bill went into conference, then it went over to the governor's office, and the governor vetoed that bill. From my recollection is the governor vetoed the bill partly because it has criminal penalties. this bill does make it a Class 3 misdemeanor, which I know has been a frequent discussion point of this committee.
So may I address that, Mr. Chair? May I address those comments?
Sure.
So I believe last year this may have gone up as a Class 1 misdemeanor. I'm not positive. You correct me if I'm wrong.
It was in this committee as a Class 1. I think we took the criminal penalty out, and I think in conference, it then was a Class 3 misdemeanor.
Okay.
That was the
Right.
compromise.
Okay. Right. And so I've had conversations with the governor's office. They would like no penalty, to be honest with you, not even a civil penalty. And my response was, well, give me something, something. There has to be some consequence for not registering. And so I think we're kind of in a situation of détente. I can say that the executive branch is in complete agreement with the entire bill except for the part that says Class 3 misdemeanor. And what I've said to his office is, look, can we just get this out of the House and the Senate into your office, and then I'll sit down with your staff, and we'll see where we are. And if you don't like it, veto it. And if we can come in agreement, we'll bring it back.
Mr.
Okay,
Chair,
now, Senator McClellan.
could we do a civil penalty instead of a,
Personally, I'm comfortable with that, but as I told the governor's staff, I didn't want to bid against myself. If he's going to veto it because it's a civil penalty, then I might as well send it up as a Class 3, and then let's negotiate from there.
yeah, but some of us might be more willing to vote for
Well, I
it.
mean, if that's what it takes to get it there, then I'm not going to argue against that. But my understanding is they don't even want a civil penalty.
This is a bill that requires a sex offender who goes to an emergency shelter to notify
Shelter staff.
that they're sex offender.
Yes.
And the hurricane or whatever, in the emergency shelter.
And it does not deny injury. And the example I gave is, I've got twin daughters, and if I went to a shelter, I have a right to know that someone is keeping track of whoever may be entering who's a sex offender. I mean, maybe I don't know that the person sleeping next to my daughters and the cot next to them is an offender, but someone on the staff should know.
Senator McDougal.
I'm going to move this along. I move to make it a $50 civil penalty.
Okay, can I weigh in?
Senator, you want to weigh in on the amendment?
No, I want to weigh in on the bill. but-
Okay, well, first let's talk about the amendment.
Okay.
Senator McDougal's offered a $50 civil penalty in replace of a Class 3 misdemeanor on line 15. Is there a second to that amendment? Okay, we've got an amendment and a second. All in favor, say aye. Aye. Okay, opposed. Okay, now Senator Peterson. The bill's
Okay.
been amended.
All right, I drove all the way back from DC to be here for this bill, by the way. One of the issues I have is we've had bills on the floor, and I see Delegate Jones here about post-release incarceration for sex offenders, okay? And I know that, but it's not the same concept, the exact same. And you can have it a Class 3, or you can make it a $50 penalty or $50 fine. You can make it whatever you want. If they violate the terms of their supervised release, they're going right back in. That's my concern. And so I'm wary about anything that might trigger what are very punitive provisions under that statute. And so I just don't think there's any way you can write this bill in a way that's going to make me satisfied, to be blunt. And I've voted against it every year for the last 4 years, usually against Cosgrove and Sproul, but now it's you. So, anyways.
Okay, the bill is before you with a civil penalty now. Okay, got motion and a second. Are there other motions or discussion? If not, open the roll.
Ayes 6, noes 8.
Okay, you saved your brethren, see? There's one more bill that we're gonna pass. So who wants to stick around for that one bill, wants to try? The next one, Delegate Mullen is on the list. Delegate Marshall, you're the next one then.
Good timing. Am I the last one for the night?
No, I said we're only gonna pass two bills.
Oh,
And we
okay.
passed
Well,
one.
this-
We
then-
defeated one, so now we got one more to go.
So do
with a
I
bunch
have a
of
move to
babies.
report 962?
What's the bill number?
House Bill 962.
962. 962. Okay, turn your attention to the delegate, please.
So thank you, Mr. Chair and members. House Bill 962 is a simple bill. And what the bill, first of all, smoking industrial hemp is legal in Virginia, federally actually, under the Federal Farm Bill of 2018. What this bill does, it adds a age restriction of age 21 of the sale and consumption of hemp intended for smoking so that these products are treated the same as tobacco and other products also. And so what the bill does is just adds that to that in the code that hemp cigarettes are illegal. The problem we had is in a case that I found out once I got here, it was a sheriff's race in southern part of the state that that the sheriff's deputy was running against the sheriff. The sheriff's deputy accused the sheriff of not following the law because the hemp cigarettes were being sold in the county, and the sheriff's deputy says they are legal by federal law. So what we're doing is just trying to add that to the code and making the restriction of age 21.
Mr. Chairman.
Senator McDougal.
So will this make the 20-year-old that buys hemp cigarettes have to pay a greater penalty than if they were to possess marijuana?
I'm just trying to.
Chairman, the answer to that is yes.
Okay. I want to know.
All right, can I ask a question? I'm sorry.
Senator Peterson.
Is this like Bill Murray and Caddyshack? I mean, is that what, I'm just trying to visualize a hemp cigarette.
It looks like a regular cigarette, it just has hemp. The reason they have hemp cigarettes, I'm gonna phone a friend.
Anybody want to describe that sensation?
So the reason you have hemp cigarettes is that,
Delegate, I'm sorry.
the reason you have hemp cigarettes is that if you take hemp oil, if you take hemp gummy bears, about 50% of that is lost in the digestive system. If you smoke hemp, it goes to the lungs and gets into your system a little bit quicker. So they tell me, I haven't done this, and so it gets into your system and
You're not
you
bringing
get to.
experience to the table?
I'm not an
Come on,
experienced
Danny.
person, so.
Oh, come on,
sorry.
man. We got somebody back here that's gonna bring the experience up.
I don't know if he's experienced, but I think Jimi Hendrix is experienced.
Howard Estes, Mr. Chairman, committee members, representing U.S. Agro Logistics. We actually produce, sell hemp cigarettes in North Carolina and across the country, including in Virginia. So these are legal products. There's no tobacco inside them. They are hemp only, so there's no psychoactive effects. This is really a CBD product that's smokable. It has a very high biouptake. So it allows the bloodstream to get in the CBD into your bloodstream at a faster rate to be able to manage epilepsy and other conditions.
Mr. Chair.
Senator McClellan.
So is hemp a carcinogenic?
It has the same effects as smoking other products. That's why we want to keep it at age 21 and older.
Okay, thank you. That's what.
So you're in favor of the bill?
Yes, sir.
And again, federally, it's already legal.
Senator Obenshain's got a question, I think. No? Okay, the bill's before the committee. Is there a motion? Senator Chafin's moving to report. Is
I'll
there a
second that, that's fine.
There's a second, okay. A motion and a second. Is there further motions or discussion from the committee? If not, open the roll. That's two.
Okay.
Oh, sorry. Delegate Jones.
Thank you.
Thank you.
Thank you.
Yeah, I hope so. Good evening, Mr. Chairman, members of the committee. This is House Bill 1437. This is an agency bill on behalf of the Department of Juvenile Justice. As some of you guys might know, the Federal Juvenile Justice and Delinquency Prevention Act of 1974 was reauthorized and amended in 2018 as the Juvenile Justice Reform Act. federal funds are tied to the language that are used in our code. So 16.1-292 permits a juvenile court to punish for contempt for violating an order after notice and an opportunity for a hearing. A limitation provides the confinement in the case of a juvenile shall be in a secure facility for juveniles rather than a jail and shall not exceed 10 days. The Federal Juvenile Justice Act has taken that from 10 to 7. And so we actually have to change our code to reflect that change as well, to draw down federal funds, about $800,000, to allow the Department of Juvenile Justice to continue to do their operations. The department is here if you have any questions, but we're doing this because the feds are basically mandating that we do it.
Okay, yeah, well, is there anybody that needs to be heard on this bill? Or anybody that's for it? Anybody that's against it? Okay. Moving second, any further motions or discussion from the committee? If not, open the roll, please.
Great way to end.
I would like to rise, but I see these faces.
Thank you, guys.
Here. And I don't want to send them home unhappy. Delegate Rome's next.
All right. Thank you, Mr. Chairman, to the members of the committee. May I proceed?
Excuse me.
May I proceed?
Yes.
Okay. Thank you, Mr. Chairman, to the members of the committee. This is for HB 113. This is to create a shield law in Virginia to protect reporters from being jailed for protecting the identity of confidential source. This is a bill I worked out extensively over the last 3 sessions with Delegate Mieros, as well as Delegate Sullivan, Delegate Heretic. The Attorney General's office has also weighed in with this as well. And I also have an expert who is here today who's been dealing with shield law cases across the country, and he's actually someone who's been incarcerated due to a lack of shield law as well. So as of right now, 40 states and the District of Columbia have shield laws. And by upholding confidentiality with their sources in the face of legal adversity, journalists can face jail time, financial hardship, and the loss of their job. This bill balances freedom of the press with public safety concerns. Journalists would still be required to reveal sources when an imminent threat of bodily harm or death exists, though such case instances are extraordinarily rare, and that's provided that in Section C from lines 36 through lines 45 that the 4 criteria and all 4 criteria must be met for that to basically go into effect. So with that, Mr. Chair, I'll be happy to take any questions.
So, and it's got a definition of journalism.
Yeah, so that's correct. First, Mr. Chairman, I would direct the senator here to line 26, where it says news person. News person means any person who, for a substantial portion of his livelihood or for any substantial financial gain, engages in journalism for a news organization. News person includes any person supervising or assisting another person engaging in journalism for a news organization. I mentioned that, Mr. Chairman, to tell the senator that on line 16 through line 25, where we define news organization, what we really worked hard on in committee between the subcommittee and the full committee process was making sure that this was dealing strictly with basically professional reporters, that this wasn't just like some guy in his underpants in the basement somewhere.
So it doesn't cover Twitter or
That's
Facebooking.
Right. This would not be applied to blogging, for example. On this is someone who is doing their job as a reporter. And when you get into section, I believe it's line, and I just want to mention this, that line 20 through 25.
Thank you.
Okay. Thank you.
I'm looking at lines 32 and 33. The bill appears to be compelled by the Commonwealth or locality.
That's right. So that was by request of the Attorney General's office that we actually included that specific language. That was to make it compliant with the Brown versus Commonwealth 1974 decision.
Okay.
Mr. Chair.
Senator Peters.
What prevents a private party from just issuing a subpoena in a private case? In other words, if I'm suing you, let's say you write an article about me, or there's an article about me that says something which I think is false or defamatory, and maybe I can somehow get over New York Times v. Sullivan, and I issue a subpoena to the Washington Post, whoever published the article, said, I need to know who gave you that statement. I think it was John Doe or Danica Rome or whomever. And I'm a private party. That's a subpoena. They would be compelled to respond to that. So this would not affect that, correct?
So, Mr. Chairman, and to Senator Peterson, one of the things I would actually try to point out here as I'm trying to get this is when we're going into lines 29 of 31, where it talks about what protected information is. And when I had worked out with the Attorney General, as you can see in line 33, 34, and 35, where it says, any protected information obtained in violation of the subsection is inadmissible for any purpose in an administrative, civil, or criminal proceeding. And I think that covers where you're going at, but at the same time, I would also note that this bill, if you're dealing with the court or a commonwealth here, that is to be, that you are basically dealing not with a defamation case like you're dealing with. Libel is a separate section altogether. When you are dealing with a libel case, you're dealing with defamation, you're dealing with an error in fact. This is dealing with someone is going to hold you in contempt of court and either fine you for $100 a day, as has happened here in Virginia, in state court, or they're going to incarcerate you until you reveal the source of that.
Okay, but hold on. But that can happen in a civil case. In a civil case, if you don't respond to a subpoena, the court will issue a rule to show cause.
So then, Mr. Chairman, I would tell the senator in that case that when you look at line 32 where it says, except as provided subsection B, no news person shall be compelled by the Commonwealth or a locality to testify. Therefore, this is not dealing with a private person.
Okay, I don't have the actual bill. I'm working off of the cheat sheet here. I just think this may need an amendment to take out civil actions.
Well, you've
But-
got somebody behind the delegate who wants to speak, so.
Sure.
And anybody else that wants to speak to this bill, I'd appreciate it if you'd come on up and.
Thank you, Mr. Chairman. I'm Brian Karam, immediate past president of the Maryland-Delaware District Columbia Press Association. I'm here to speak for this bill. I've testified in 6 states on similar bills. I was incarcerated myself 4 times for trying to keep a confidential source. And when I was with America's Most Wanted, we had a case in Farmville where I was nearly incarcerated here in Virginia when we were working on a murder case. We worked it out and I was not. What I want to speak to in this bill is how it's constructed, and I may be able to speak to the Senator Peterson's question. This bill defines journalists. Many states define journalism. This bill defines what a journalist is and is pretty good about excluding bloggers and people who do not work professionally. It is a well-crafted definition of a journalist. It also gives exceptions and how to meet them. It is actually one of the stronger bills that I've seen across the country in doing so. It protects reporters, and in many states, these are bipartisan. These are supported by bipartisan efforts. What we're talking about, Senator Peterson, when you were talking about civil cases, you can indeed be brought before a court for a civil case in all states and incarcerated. However, the difference is in a civil case that does not involve a local or state or federal government, the risk, the scale, the wall is higher. And many times judges do not find in favor of a civil case because it's merely 2 parties arguing over something. It does not involve a case that can lend itself to immediate incarceration.
Yeah, let me get to the point. Let's say you write an article about, I'm not going to say me because I could care less, I'm a public figure, about my client. And you say something in that article that's, in my opinion, defamatory or, devastates their business. And I say, I'm going to file suit against you. And you say, well, I had a basis. I had a confidential source. I said, well, let me know who the source is. Oh, I can't do that. I said, okay, I'm going to send you a subpoena, or I'm going to subpoena your newspaper, and you're all going to produce all the information. I said, well, no, we don't have to.
Well,
help me out here.
Okay,
how do
so
I get to the
here's
truth
how I
in
help
that
you out.
situation?
First of all, these are well-established court cases. Is it a public figure or is it a private figure?
It's a private business.
Then there is a much lower bar to overcome, and they, in fact, may be compelled. This is protecting reporters.
I think you need to figure a way to exempt out civil cases.
Well, no state that I've testified in has ever exempted out civil cases.
I don't know if you've testified in all 50.
I have helped write 6, and I have testified in 8, and I have consulted in about 20. So no, not all 50, you're right, Senator. However,
I
what,
second Senator Peterson's amendment.
Yeah.
but if you wish to do that, you would also not be unique in doing it. There have been states that have.
Okay, I want an amendment that would basically exempt out civil cases. Otherwise, I think this can be a
Got a
problem.
motion and a second to amend in concept out civil cases. Does that only require one line in the bill, or?
Mr. Chair, I think the amendment that I would make would be after line 32, after by the Commonwealth, put in a criminal case, so this would be in criminal cases only, and then strike or a locality. So since criminal cases are just essentially brought by the Commonwealth, it would be, shall not be compelled by the Commonwealth in a criminal case to testify about.
What if it's violation of a local criminal ordinance?
It's still brought by the Commonwealth and by the locale. I mean, I guess there are some cases where a county attorney could bring in a local ordinance violation, but typically those aren't criminal. Those would be a civil violation.
But
If
Chairman, the insertion could be on line 33 after the word locality.
Yeah.
Okay.
That's the art of politics. But Mr. Chairman, may I offer this? In the states that I've covered where they have had this codicil or this amendment, the wording has been, the standard wording is where no locality or no government is a party to or has jurisdiction over. I don't know how you wish to word it.
Yeah, I would just say this section shall not apply to civil cases, or just somehow put it in there.
Yeah. Just trying to help.
Okay, I think we understand the amendment. We understand what the intent is. We don't have the words actually yet, but in concept, let's adopt the amendment. A motion and a second. Everybody in favor of that amendment, say aye.
And
Opposed?
Mr. Chairman, I see that as a friendly amendment.
Okay.
I understand.
Do we need further discussion, or do we have further discussion on the bill?
I do have a question, Mr. Chairman.
Okay, Mr. Benjamin.
You will see.
Sorry, keep something out there.
You will see a number of additional conditions that begin with subdivision A on line 20. You have A, B, and C, and D. As the bill is currently worded, those additional qualifications apply only to subcategory 4,
That's correct.
business. And is that the patron's intent?
That is, Mr. Chairman, I would tell council that, yes, that is the intent. That was done at the request of both the delegates Herrick and Sullivan, as we were trying to distinguish between an online news reporter versus blogger.
And that's my next question, Mr. Chairman. On line 16, we refer to a newspaper as being a news organization. So my question would be, can a newspaper be solely electronic? And so if somebody issues electronic transmission at regular intervals and has its general circulation, does that fit the definition of newspapers?
Mr. Chairman, I would say that that is compliant, and the reason that's compliant is that just about every news organization in Virginia, as our
online.
As one of the folks here from Virginia Press Association will be able to attest to, most of them belong to a news organization, or to the sort of news organization like Virginia Press Association or Virginia Association for Broadcasters in the first place. And so that if you have a printed copy, that is already part of what makes a newspaper, right? As opposed to an online only source for news.
Mr. Chairman, that's actually my question, because none of the definitions require a newspaper to be a hard copy. And so the question is, can a news organization also be something that is totally electronic, so long as it's issued at regular intervals and has a general circulation?
What was that? Yeah, Mr. Chairman, what I would tell council then is that if it fits the other qualifications, then yes, but at the same time, if it does not, if it is a newspaper by definition, it has a print copy. However, if it does not have a print copy, let's say you are a newspaper that has lost its print copy because we have seen what's happened to the industry, and I've worked in newspaper for 10.5 years, I've watched this happen. You then will have a news organization that goes to online only, right? And if you are online only, then at that point, you're falling into Romanet 4 for business that, by means of photographic or electronic media, engages in journalism and employs an editor, blah, 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 and then goes through the 4 subclauses after that. And so by making sure that we had all of these subclauses from lines 20 through 25, we really did our best to distinguish between, a news person working for a news organization, whether they have a printed copy, whether they have a broadcast copy, or whether they are an online-only entity. And that if you are an online-only entity, then you'll fall into one of those four categories. And I would also tell you, Mr. Chairman, that the final of the subsections in D, where it says it's continuous operation since 1994 or earlier, that is entirely designed to deal with legacy newspapers that have shifted onto that are now online-only platforms, because that was basically October 13th, 1994 was the launch of Netscape. And so that's the sort of error that we're looking at here, that if you've been in continuous operation before then, you still are.
So what is a news agency on line 17?
Sure. So, Mr. Chairman, where we say it's news agency, recognized press association.
Nope, it's news agency,
Right.
comma, recognized press organization. So what's a news agency?
Right, so a news agency in this case, you could be dealing with Reuters, you could be dealing with Associated Press, you could be dealing with...
He's asking, is it defined anywhere in law, in the code?
Oh, I would
or-
refer to council to see if we had a prior definition of news agency, as that was the recommendation of language that came back from Division of Legislative
And my
Services.
thought, and I don't want to be cute, my thought is, going back to my first question, Twitter, Facebook, bad news agency. We don't have if we don't have a definition, doesn't that just blow the doors wide open?
I think what we're really trying to get at there is
trying to get at, and I think that's fine.
Okay. So, Mr.
Can we
Chairman.
strike that?
Mr. Chair,
Just strike news agency?
I would say that news agency does not appear to term in the code, so it
And isn't it superfluous anyway?
That's fine.
Strike, okay. Got a motion and a second to strike the phrase, news agency. All in favor, say aye.
Aye.
Opposed? Okay, and there's somebody else behind you that needs to speak, and we need to hear from everybody.
I will be very brief. Mark Hickman on behalf of the Virginia Press Association, here to strongly support the bill, and we thank the delegate for bringing it forward again, and we hope you will advance it.
Okay, the bill is before the committee. Is there a motion
Yeah,
or?
Before we make a motion, first of all, I want to congratulate the delegates. Clearly put a lot of work into this bill. There are other privileges. There's attorney-client, there's pastor-penitent, there's spousal privilege. Are those, typically, are those all in 8.01, or, where do we find those? Are those common law?
Mr. Chairman, there's an evidentiary section in 8.01 that contains
Okay.
a number of those privileges.
Okay, so we've got it in the right section of the code. I'll take silence for a yes. Okay, that's a geeky lawyer thing like me.
I'm just a lowly former investigative reporter in lawyer's world here.
Okay, is there a motion on the bill?
Move to report. Second.
A motion and a second. Are there other motions or discussion?
Yeah, let me just, and I know we've talked this to death, and just so everyone's clear, we took out civil cases, so what we're really talking is about grand jury investigations, and, potentially if it goes to trial, if somebody, and I assume we're mostly talking about the prosecution. Obviously, if you're a defendant and you're scrambling, and you're that lawyer, that may be a time you're gonna wanna hop over these bars.
Right, and Mr. Chairman, I would just simply say to that we're trying to basically keep reporters out of jail. This is, you're dealing with criminal cases
That may
here.
be your purpose, but. Okay.
Well,
Criminal case only.
I'm not gonna talk myself out of the sale.
All right, okay, fair enough.
Okay, open the roll.
Oh, it seems to work.
Okay. Delegate Corey.
Uncontested calendar, yes. Thank you, Mr. Chairman.
And we were just talking, I would suggest there's civil cases where the Commonwealth is a party.
That's fair.
So you might. Yeah, I understand, but you still have cases involving the Commonwealth. So,
Mr. Chairman, if you need to talk to me about that offline, I'll be happy.
no, all I'm saying is we have a few days, see what you can figure out.
Okay.
Okay, Delegate Corey.
She's going to stay and do this for me, too. Thank you, Mr. Chairman, members of the committee.
What's your bill number?
My bill is 1063. It is a very simple bill. It simply abolishes suicide as a crime in the Commonwealth of Virginia. Maybe you didn't even know that it is a crime. I've been working with a number of groups of families of people who have committed suicide and a number of national groups who are interested in preventing suicide. And they are all coming together to say that this remnant of English common law actually stigmatizes mental health problems, and it is a barrier to working to prevent suicide. And there were a number of people who came to speak. I honestly don't know if they're still here. Say, oh, okay. Chairman Deeds, may they? Thank you.
Thank you. Chairman, members of the committee, my name is Jenny Skatine. I'm with the Disability Law Center of Virginia. We support the intent of the bill, and I'll defer to law enforcement who's here. There's an amendment added that we think is unnecessary because they still can.
There's no amendment.
The amendment has been removed. Okay, then I'm sorry. It went on and off from the civil and the criminal. Okay, gotcha. Okay, well, good. Well, then we support the bill and the intent. It's a great bill. Thank you so much.
Hold on a second.
Yes.
All right. I have
Yes,
to be,
sir.
I have to be the skunk at the garden party here, but
Please.
This bill has come up many times, and the issue is not whether or not somebody committing suicide should be a crime. It's whether the person assisting them is an accomplice to a crime. That's the issue.
No, it's not about suicide. It's not.
Okay, just because you say that doesn't mean it's not. It's whether or not someone who assists in a suicide is an accomplice to a criminal act. That's the issue.
Actually, Senator Peterson, I disagree with you. There is a separate part of the code that deals with assisted suicide and the consequences of someone assisting someone in committing suicide. This is one line. This is about making suicide a crime or not.
Okay, well, and I appreciate that, Delegate Corey, but I don't
Yes.
think anybody in the history of the Commonwealth has ever been prosecuted for suicide.
I'm not sure, Senator Peterson, that you heard me talk about why I've been bringing this bill forward, and you haven't heard it many times. I did it once 2 years ago, and now I'm doing it again at the behest of the people whom I mentioned who are interested in preventing suicide and giving people who are having suicidal ideation and/or mental health issues more of an opportunity to come forward, to seek help, not be stigmatized.
Okay, well, Mr. Chair.
Yeah, Senator Peterson.
No, just to say bluntly, whether we pass this bill or don't pass this bill, I don't think that's going to be relevant to that. But here's the point, is if we suddenly outlaw the common law crime of suicide, and I'll take you at your word that there's an 18.2 crime against assisted suicide.
There is.
Is that,
Yes.
I'm looking at Senator Benjamin,
Okay,
who is my personal legal counsel.
okay.
Can you give me the 18.2? What's the code section? No, that's what we have right here, Joe. The word suicide doesn't appear in 18.2 according to my other personal counsel.
No, it's in, let's see. So are you asking me what section of the code my bill is drawn to?
No, there is no section of the code on making suicide illegal. You say common law. That means it's not in the code.
Common law crime of suicide.
Right, that means it's not in the code.
It is in the code.
Ma'am, it's not in the code.
Is there an 18.2, 16.
18, if it says common law, it means it's not in 18.2. So there's nothing to repeal.
Let's ask staff, is there anything in the code on suicide?
The bill that I have is drawn to 18.2.
No, it's not drawn to it.
No,
It
okay,
creates a
you're right.
8.2.
You're abolishing something
Okay.
that's not in the code.
Well, if that is actually the case, it's wonderful to hear, but it would have been nice for someone to have said that
Well, you're in Senate
years
courts now, so I
ago.
don't want to tell you.
Yeah,
Ma-
I'm not
Mr.
sure
Chair,
that's,
Mr. Chair, just for the delegates.
please.
So a common law crime means it is not in our code.
Okay.
It was a crime when the colonists came to Virginia in
Right.
1607.
Right.
Because it was a crime in England.
Yes.
And because it was then, it
Yes.
still is now. So
Yes.
that's why I think the problem is because the way we prosecute assisted suicide is you are an accessory to the common law crime of suicide is what CHAP is saying. We're trying to verify whether there is a
Okay.
separate code section that makes assisted suicide a crime to address this concern.
Thank you, Senator McClellan. I do understand, but I have to tell you that more than 20 states have actually abolished the common law, I'm sorry, I'm losing my voice, crime of suicide. And actually, every European country has done that since the 1700s.
And I support your bill. I'm just explaining to you.
You know, I
because
understand.
Yeah, okay, thank you.
I do, and I thank you for that explanation.
Mr. Chairman. and
But
just-
if there are any people here to speak about it, with the exception of the woman who just spoke, I would really like them to have the opportunity.
Mr. Chairman,
Senator Overton.
just another issue to throw out there. I mean, there is a
Yeah.
body of law from the Supreme Court dealing with civil cases in Virginia in which wrongful death actions are impacted by the fact that there is a common law crime out
Yes.
there.
Yes.
So this has the potential to really potentially significantly alter the landscape with respect to civil litigation as well. Maybe that's the intention.
Mr. Chairman. Okay, let's hear these people.
Mr. Chairman,
Yeah,
can I
Senator
stop for another
Sherwood.
clarification really quick?
Go ahead.
In my search, there is a statute in 801 on the civil side to allow family members to get an injunction against assisted suicide.
Yes.
So anyway, that's out there. No, not criminal. So,
Let's hear the speakers.
Yeah.
Okay, who would like to speak in
All right.
favor of the bill? No.
My speaking has nothing to do with assisted suicide, everything to do with the idea that suicide was considered a crime. And I'm speaking for my son, who took his life after years and years and years of us all. He didn't make it to high school. That's why my last two pictures are blank. After lots of trying to help him through he had serious mental illness. And mental illness is 90% of the people who take their life have, the National Institute of Mental Health says that 90% have had mental illness. And it's a health issue. It's not a crime. And calling it a crime devastates loved ones further. So if it is anywhere on the books listed as a crime, I urge us to change that.
Mr. Chairman, committee members, my name is Steve Mittendorf. For those who do not know me, I'm the proud spouse of Nicole K. Mittendorf, who was a distinguished firefighter with the Fairfax County Fire and Rescue Department. Nicole died by suicide on April 21st, 2016, after her remains were located in the Shenandoah National Park. This concluded a labor-intensive and exhaustive 6-day search. The search for Nicole and her suicide garnered not only local, but national attention, sparking a movement amongst women to speak out against sexual harassment and bullying, especially in our male-dominated professions of public safety. In her youth, she served as a lifeguard on the banks of Lake Michigan and later in life found her calling as a firefighter. What Nicole is not is a criminal. Members of the committee, this evening, I stand before you as a survivor of suicide, not because I have attempted to take my own life, but because I lived in the aftermath of losing my soulmate and partner. You have legislation today before you that would abolish suicide as a criminal offense under common law, legislation that can and will help to alleviate the burden that survivors are left to bear. The legislation should not be about politics, religion, or the antiquated reasoning of this is how it has always been done. In fact, many of us who are here today in support of this legislation vary in political and personal views. However, we are a bipartisan group coming together for the very purpose of effecting change. I ask you today, members of this committee, regardless of your political affiliation, to come together in a bipartisanship fashion and vote in favor of this legislation. You can and you will help the hundreds of thousands of survivors who call the Commonwealth home by easing the burden they are left to bear. In closing, I use a quote from the Greek philosopher Socrates, which is, "The secret of change is to focus all of your energy not on fighting the old, but on building the new." Mr. Chairman, members of the committee, today I invite you to join all the survivors of suicide as a part of building the new. Thank you.
We're going over, but continue. Have all your witnesses speak, if you like.
Mr. Chair.
Yeah, go ahead.
And I want to thank everyone.
Senator Peterson?
Okay, and I want to thank everyone for testifying and for sharing your stories. I think your stories are important, but it's important to note we've never made a conscious decision under 18.2 to make suicide a crime.
Okay.
So it's never, to my knowledge, ma'am, just let me speak.
I wasn't going to say anything.
It's never been prosecuted in this Commonwealth.
Okay.
To my knowledge, and I've got a little bit of knowledge on this topic, there's never been a prosecution for suicide in this Commonwealth.
Well, let's hear them
So hold on a
speak
second.
first.
So my point is that if we repeal a crime that does not exist on our code books, and if we do so out of a means to sort of try and help you, there's going to be unintended consequences such as people that either assist in suicide right now, which is not apparently, and we've been looking for it under 18.2, is not a crime. There could be issues with civil cases in which somebody causes somebody to commit suicide, and perhaps they may no longer be liable for that. I mean, there's all sorts of sort of issues that we may be impacting, which none of this is going to bring anybody back.
All right,
And
let's hear the witnesses, and we can have the debate.
witnesses, John.
No, we haven't. It's my understanding, their people have not spoken. Am I right?
Yeah, we lost two of the
okay.
advocates because of the time. My name's Sharon Webster.
Okay.
Senator Peterson, 6 years ago, I went before the same Senate committee, and at that time, a woman by the name of Shirley Ramsey was describing the 4 or 5 deaths in her own family of suicide, and also she was reading the notes from her recently deceased 15-year-old son. At that point, you stopped her and you asked her, well, I'm sorry if you're lost, but what do you think of assisted suicide? I want to tell you that this has nothing to do with assisted suicide. It never did. That's the first thing. The second thing is we do have common law on the books as suicide as a common law crime. I differ with you in that way. I know you have concerns about possibly someone leaving a loaded gun on a table or a bottle of pills, and that makes someone an assistant to suicide. But let me tell you, someone falls down the steps and you don't investigate. Someone leaves an cake with icing on a counter. You don't, and they have a daughter that died of diabetes. You don't investigate. We're asking that this be considered as a regular health crisis, which we have, and that is what it is. My concern is that common law crime of suicide is on the books. It says, though, it is not enforced. And whether it's on the books as a code or not as a code, it should be taken off. And one other thing, there's hypocrisy in this because we call a soldier, we give him a medal for bravery, but we then call him a common law criminal if he dies by suicide. My ex-husband is a veteran of Vietnam. He has PTSD and his Agent Orange disability. And every day is a struggle. The legacy of those who serve, whether the police, the EMTs like my deceased daughter, firefighters or soldiers that die by suicide, their legacy is tarnished by a common law crime of suicide. If it's not a common law crime, England abolished it over 50 years ago. Ireland abolished it in 1993. And we have Virginia universities that are great, and we have a push for high tech, but still on the books, we have the common law crime of suicide. The American Foundation for Suicide Prevention, as well as NAMI, the National Alliance for Suicide, the National Alliance for Mental Health, have both endorsed this. The American Foundation for the Prevention of Suicide did a legal search, and they said, yes, it is considered a common law crime, and yes, the proper term is decriminalized. And that search was done over 5 years ago. So I've been fighting this and fighting the term, and the fact that it is on the books as a common law crime, it should be taken off, whether it's codified or not. And that's how we feel. It's antiquated. Thank
Next
you.
person, come up. Yeah, come on up.
I'm Andrea Walker, and I just wanted to say that I'm a practicing Catholic, and as a practicing Catholic, I really am interested in terms as far as saving lives. And this law really needs to be abolished. It is an impediment to suicide prevention initiatives, truly. Those initiatives, are to open dialogue, promote healing, and to save lives. It is an antiquated law, it's barbaric, and it's time it was abolished. And please do so today. Thank you for listening.
Okay, Senator McClellan.
Thank you, Mr. Chair, and I don't know if this is for council or not, but it seems to me, again, intentionally causing someone's death has to fit in the definition of an existing crime, so that even if we abolish the common law crime of suicide, if you assist in someone's suicide, you are intentionally causing someone's death, and that has to fit in some other category under crimes against the person. So is that accurate,
Mr.
staff?
Chairman, I think the senator is accurate. Charles and I were just discussing this. If I take the steps necessary to cause somebody else's death, even at their request, if at their request, because they're too incapacitated, I place them in a car, close the door, and turn it on and stuff something up the exhaust pipe so that they are thence killed, it's not them committing suicide, it's me committing homicide. And I think that current laws would criminalize that, would prosecute me.
Yes.
I think you're correct.
I think you'd lose that case in a heartbeat.
Mr. Chairman.
Senator Obenshain.
Well, that certainly is one scenario. It's easy to conjure up scenarios in which it is not the affirmative act of the second person that actually brings about the death, such as the one described by Mr. Benjamin. My concerns are a couple. One, you're not taking suicide out of the code. You're actually putting it in the code. You are adding a line in the code, a section that addresses suicide that did not exist there. Number two is that this impacts other things. I'm a civil practitioner, Senator Peterson's a civil practitioner, and it affects civil litigation. There is something, there's the Boyd Graves Conference of the Virginia Bar Association that looks at these things. We try not to be improvident. Every time we do something like this, it has secondary and tertiary impacts. And as a consequence, it would be my hope that we would pass this by for the year and send a letter requesting that the Boyd Graves Conference take a look at this issue.
Mr. Chair.
Okay.
I would make that as a motion.
Senator McClellan.
To continue.
Motion's been made. Senator McClellan.
Yes, speaking very briefly to the motion, as long as they actually look at it. Because here is the problem. This is not the first year this bill has been brought. Just let me finish,
Just
chat.
a minute, one at a time.
Let me finish, chat.
I thought you were finished.
I'm not finished. There are two reasons to bring this bill. And I have a friend who has suicidal idealization. And never, for a long time, did not seek treatment or help because of the stigma surrounding suicide. And eventually did get help, but a lot of people don't. And eventually they act on the fantasies because they don't get the help they need because they're afraid of the stigma. So that's the first problem we're trying to address. The second problem we're trying to address is the doubly devastating impact on the family.
Yes.
When first you have lost a loved one and you live with the guilt of, could I have done something to prevent it? And then you are doubly devastated because the world has put criminal on your lost loved one. And so if the Boyd Graves Conference is actually going to look at this and make a recommendation, that's better than nothing. But this is not the first year this has been done, and we have got to figure out how to fix this.
Mr. Chairman,
Mr. Benjamin.
if suicide is a crime at common law, then the answer to the question is this. Virginia Code Section 1-200 provides that the common law shall continue in full force except as altered by the General Assembly. And so if the General Assembly has not addressed the common law crime of suicide, then the common law crime of suicide is still in existence.
Mr. Chair.
Okay, just a minute. Okay,
And I hate to interrupt Senator
Senator
Benjamin.
Peterson.
If we come back with a bill that says assisting is suicide is a separate crime, a class 6 felony, whatever we want to make it, then let's take up that bill. But if we just we just put this on the code section, because we don't mention suicide anywhere in 18.2. And if we just put this alone in the books, and there's going to be all sorts of unintended consequences, I can't vote for that. And again, if we come back with a bill that says 18.2, we're going to deal with assisted suicide, and maybe I'm the only person that thinks it ought to be legal, maybe everyone else thinks it should be legal, but that to me has got to be addressed. So I support Senator Obenshain's motion. I heard what Senator McClellan had to say, but that's where I stand.
Mr. Chairman, may I?
Go ahead.
Senator
Corey.
Peterson, I understand what you're saying, but I do have to let you know that the Courts of Justice House Committee, criminal and civil, both have debated this and put amendments like you are recommending on and then taken them off. And that's why the bill appears as it does before you. I think that adding any language about assisted suicide increases the stigma, and it's not something that I would like to do. So thank you for your input.
Okay, we have, I think, a motion to carry it over for the year and have the Boyd Graves Conference look at it. Is that Obenshain's motion? Senator Obenshain, is that your motion?
My letter was motion to continue with the letter.
To the Boyd Graves Conference. And is there a second? There's a second. Are you ready to vote on that motion? All in favor of the motion, say aye. Well, I guess we have to put it on the board. Vote aye, all opposed, no.
Ayes 10, noes 3.
Maybe we'll come back and something next year.
Well,
Okay.
thank you. I definitely will be back.
I
Thank
know.
you very
Yeah.
much.
Thank you very much, and thank you to those that spoke on the bill. This is a very important bill. We appreciate you coming and spending your time with us and expressing your views. Now, I don't know how many patrons we have out there. A bunch of them.
5 or 6.
Well, six more. Which ones are the quick ones? Are there any quick ones? Okay, I have Delegate Mullen first. I'm just going down the list here. We can go to 9 o'clock or midnight, whichever you prefer.
As someone who's used to going to midnight, I would prefer not to do that, Mr. Chair. So I have HB 660, which is persons who are charged with a first offense being able to be placed on probation. So
Chairman.
what?
Senator Peterson?
No, Ceraville. Can I make this easy?
Yeah.
I mean, we approved a similar measure by Senator Deeds, and also one that was more broad by me, and given the admonition we received from Senator Norman about trying not to have conflicting policy
I'm
direction
not
emerging
gonna
from our body,
object.
I
That
believe
is-
that we can form this bill to make it the same as my bill and deal with it in that posture.
Second.
As in so many things, I agree with Senator Serval.
It's
And,
been moved and seconded that the bill be conformed to what, Senator Deeds' bill?
Mr. Chair, to Senator Serval's bill, which is Senate Bill 489.
489. I think this is 660.
The 286 bill is the Senator Deeds bill, which, as Senator Serval just explained, is more narrow than his bill. His bill was Senate Bill 489, which was the broader bill on this policy.
Which bill are we conforming this to?
Sorry, Mr. Chair, I'm just trying to figure out who are we conforming to, the broader or the smaller bill?
broader. That's
Just
the
so I
question.
can be aware
That's the question.
of what we're doing here.
Senator Serval, so we conform not to Senator Deeds' bill, but your bill, which is what?
Which is the broader bill.
Senate Bill 489, which provided for the deferred dispositions in basically any criminal case.
Right.
While I'm not sure that I can agree with that, but I think Senator Serval and I have had discussions about this.
Well, the question is, which one do you want to conform to? Because
So I would not feel comfortable conforming mine to Senator Serval's bill, but he and I have had a number of discussions about that bill in particular. And now, if there was a senator, if there was a motion to conform to Senator Deeds' bill, I think that might be slightly different in its application.
Is there a motion to conform to Senator Deeds' bill?
Is that what you want?
Or not, or.
Is that what you want?
If I had to pick, which.
That's what you would pick.
That is, if I was going to pick, I would pick Senator Deeds' bill over Senator Serval's bill.
So moved.
I already made a motion for my bill.
So
we have one
I will
motion.
do whatever the committee tells.
We
I'm
have-
just here.
Just a minute, we have one motion.
I'm sorry, I work here.
To conform to Senator Serval's bill 489. Now, is there a substitute motion or not? Okay. All in favor of the motion to conform to Senator Serval's bill 489, say aye. All opposed, say no. Okay. The ayes have it.
That is
All right, all in
the
favor
will of the committee.
of reporting the House bill, the substitute to House Bill 660.
Mr. Chair?
Yes.
May I have a question, just sort of parliamentary inquiry?
Okay.
So the title of my bill under 660 is Property Crimes, Larceny, and Receiving Stolen Goods. And Senator Serval's bill applies to all bills, including violent felonies. And I'm wondering whether or not we might have a constitutional issue, given the fact that you have now conformed my bill to something that is well beyond the scope of the initial description.
Well, they're close enough. I don't think there's any constitutional question. Anybody think there's a constitutional
No,
question?
they both involve deferred dispositions, and they're both deferred dispositions.
Yeah, okay.
Including, by the way, rape, murder,
Okay.
and incest.
Well, it would have to go to the House to be accepted or not. And if you want a conference, that's a possibility too. But that's what we've got here. All in favor of the motion to report the substitute to House Bill 660, vote aye. All opposed, vote no.
Ayes 9, noes 3.
9-3.
Thank you, Mr.
Okay.
Chair.
It's got to go to the House to.
I would imagine that would
understand
happen.
that. Okay, do you have another bill?
I do, Mr. Chair. So my additional bill is 673, which does two things in primary effect. First, it adds emotional cruelty. It amounts to torture of a child.
Okay, we have a substitute.
Oh.
Have you seen that? We fixed your bill.
Pardon me.
Yeah, take a look. And, staff can explain what we've done.
Mr. Chair, I have not seen the substitute. I don't know from whom this substitute is from. And so
Why don't we do this? Let's staff explain the substitute.
I am quite surprised by this.
Charles,
I would love to be able to know a little bit more about what this substitute might be, given the fact that we are talking about torture of a child.
We're going to. Okay, Charles, you want to explain it?
Mr. Chair, the bills that came over from the House amended a section in the Labor Code, because initially this bill was drawn to labor. And now that section has been relocated to Title 18.2, which is a new section numbered 18.2-13 371:1. The language essentially tracks the existing section entitled 40.1, but there is a difference. Under 40.1, the original language criminalized both a negligent and willful causing or permitting of a child who is employed to be tortured, physically, psychologically mutilated, beaten, or cruelly treated. And Delegate Mullins' bill had it as a Class 6 felony for a negligent causing of that and a Class 4 felony for a willful causing of that. This committee has expressed some concerns about criminalizing negligent activities, so the negligently was removed, and just a willful causing was remaining, which is punishable as a Class 4 felony. So there is a removal of a negligent causing, which is current law, and now it just makes it a willful causing.
So, Mr. Chair, my personal request, independent of this bill, is that I might be able to be made aware of the committee's actions. If that is the will of the committee.
You want to pass it by temporarily or for the day or something?
So
All right. To look at it further?
Mr. Chair, I actually know this code section well. I've prosecuted under this code section since 2007. I have prosecuted more cases of domestic violence, sexual abuse, and juvenile abuse than probably anybody else in this room.
Well, what do you want to do?
And I am not happy with this change, but if that is the nature that we need to be able to do, to be able to get this out.
Well, what I'm saying is, you want to temporarily pass it by or a day for a
Mr.
day,
Chair,
or
I
what?
know this section backwards and forwards.
okay.
So
I
the
think
question is, I guess my question is, where does this come from?
Well, it came from our, looking at it, and I think your
understand.
bill was in workers' comp or something like that, was that right?
Mr. Chair, so there is a child labor section under 40.1 that is one of the two child cruelty sections that are routinely charged together. Under my bill as it was introduced, I actually brought it back to 18.2, and it was the will of the committee in the House that it remain in 40.1. There are two code sections that involve child abuse and neglect. Both are Class 6 felonies. My thought was if you torture a child, that it should be a Class 4.
Well, I think the issue, though, had to do, we didn't think that was a proper section of the code.
So I guess I am taken aback by the fact that I'm seeing this for the first time. No, I know the section.
Listen, I
know the
understand
section,
that.
and I can feel the will of the committee.
Well, I mean, I understand it's the first time you've seen it, and that's why I'm suggesting if you want to take some, either temporarily or
No,
for a day.
Mr. Chair, Mr. Chair,
I would just say, Mr. Chair, to the delegate, this is the first time any of us have seen it.
Delegate, you said the will of the committee. I haven't even seen this before.
So
I'm actually- I'm
I
interested in
am
what you
wondering
have to
where
say.
this came from,
Well, let's
Mr.
take
Chair.
it by temporarily, okay?
Well,
that everybody can look
so
at it
I
more
understand
carefully.
this section, and I'm happy to take a seat for a little while, and I understand, but I don't know to whom this is attributed or.
Mr. Chair,
Yes, Senator McClellan.
let me help my friend for a minute. So this committee gets grumpy after a while. You might be better off taking your bill.
I will do
by for the
exactly
day.
what the committee wants. I can take this by temporarily, or I can take this by for the day, whatever is the will of the committee. I will say this, that if it is the will of the committee to accept this amendment, it's not something that I'm super excited about, but it is I prefer not
Who's
the
moved the amendment?
perfect to be the enemy of the good.
Where'd it come, I mean, who's offered it? Do we have it before us?
Yeah, I think, do we, all right, I'll offer the amendment. Is there a second?
Second.
Okay, all in favor of the substitute?
Okay, before, can we, hold on a second.
Yeah, say all in favor of the substitute.
Hold on a
Say
second.
aye.
Mr. Chair.
Go ahead, Senator Peterson, hurry up. We got a lot of
Apparently-
cases here.
I understand that, sir. But the sponsor's not happy with the amendment. I don't know anything about the substance bill, and I don't do any of these type of
Well,
cases.
that's why we're taking it by temporarily, okay? Now
So,
we're taking it by
if I
temporarily.
might be able to
And
step
we're moving
aside.
on to
Thank
some
you.
other bill, okay? All right, next person is Delegate Scott.
Good evening, Mr. Chairman. This bill is a House Bill 1462. This bill simply allows the magistrates to do what they were doing prior to 2012, which is hear presumption cases. I believe there's a line amendment.
Mr. Chair, there is a line amendment, which is on line 63. After the word section, it strikes the remainder of that line 63 and through Commonwealth on line 64. The bill as written doesn't do what the delegate wants it to do, and this amendment makes it want to do what the delegate wants.
Exactly. Thank you. Thank you, Council. So
Okay. So,
I'd ask that the committee accept the amendment.
Mr. Chairman.
yeah,
Mr.
Senator
Chairman.
McDougal?
So if I'm understanding, not having physically seen the amendment, right now, only a judicial officer, a judge, can hear a rebuttal of a presumption against bail case. This would allow a magistrate to also hear the rebuttal of a presumption against bond case. Is that my understanding?
Yes, yes, sir. Mr. Chair, I would answer the senator by saying yes. And that was the law prior to 2012. Nothing has changed. That was up until 2011. The magistrates are trained to hear this information, and they still hear it now. But after they hear all of the information, they're not allowed to make a decision. So this will increase judicial efficiency. This is what magistrates are trained to do every day. And then they'll still have the obligation to protect the public and to make sure that the defendant will show up to court. This will improve judicial efficiency.
Okay. All right, so we're just deleting the bail in the course of the section, deleting after notice and an opportunity to be heard has been provided to the attorney for the Commonwealth, right?
Right, that's
okay. Everybody's happy about that? Is there a motion to adopt the line amendment?
So moved, Mr. Chairman.
Is there a second?
I'm sorry,
All
Mr.
in
Chair.
favor of the motion, say aye. Aye. All opposed, no. Okay. Any questions of the patron?
Mr. Chair.
Yeah, Senator
Could staff just read me the amendment now as it?
So the sentence would read in subsection D, the first sentence has been struck, and the second sentence would now read, for a person who is charged with an offense giving rise to a rebuttable presumption against bail, any judicial officer may set or admit such person to bail in accordance with this section, period. The language after the section, after notice and opportunity to be heard, has been provided to the Commonwealth, has been struck.
Question, Mr. Chair.
Yeah, Senator Morrissey.
Delegate, first of all, thank you for your bill. On line 62, judicial officer, should I read that to include magistrate?
Absolutely.
Should I only read it to include magistrate?
I believe it's only a magistrate or a judge based on the information I got from counsel on the other side of the house. I would hope that counsel here will confirm that.
That's correct.
I have written here that somebody said the Virginia Bail Association, their ideal amendment is, quote, magistrate shall set a secured bond for presumptive offenses, and period, end quote. Is that still in there, Steve, Mr. Benjamin?
No.
No, okay. Anybody want to say anything about that?
Mr. Chairman, I'll say something about it.
Okay, Senator Sherrill.
Mr. Chairman, from my perspective, again, we hire these judicial officers to exercise their discretion and to figure out when secured bonds are appropriate or not appropriate, and if they're not doing their job, they ought to be fired. But for us to sit here and legislatively draw a bunch of bright lines about when and where they ought to be doing the discretion we give them, I think is inappropriate. And so I think the bill is a good idea to restore some sanity to our system.
Mr. Chair.
Senator Morrissey.
While I too like the spirit of the bill, I just want to make sure that I understand it. Was the genesis of this bill because some magistrates looking at the crime saw that there was a rebuttable presumption against bail and then automatically would deny bail? Was that the reason?
No, the genesis of the bill is magistrates are prohibited in presumption cases from granting bail.
Right. Okay. All right.
Yeah. All right. Okay. All right. Anybody want to speak in favor or against the bill?
Move the bill be reported.
Now, here's somebody who wants to come up. You support it. Anybody against it? Somebody coming up or not? You coming up? Okay. All right. Thanks. And your name?
I'm Dave Bourne. I'm the president of the Virginia Bail Association.
Yeah, that's right. I got your note here.
Yes. We're not certainly not advocating that everybody should be on a secured bond. You have to excuse me for a moment.
Mr. Chairman, members of the committee, Rick Nagel, I represent the Virginia Bail Association. And we've worked with Delegate Scott. He gave us a lot of time on this, and we offered some language which the chairman had put forth. And I go throughout the country and I testify in front of committees with states that are doing bail reform. And we seem that our opinion, and the committee may agree or disagree, but our opinion is that this is a big policy shift to go from presumptive offenses, which are very serious felonies, where a magistrate could potentially release someone on their signature with no level of supervision whatsoever. So that was our concern. Again, Delegate Scott was good to work with. So that's what we see it as. And if anyone follows what's happened in New York, they had a huge bail reform package pass January 1, 2020. It took effect. And I'm not advocating that this would create a New York, but I think it would create a slippery slope if magistrates started releasing folks charged with very serious and violent felonies. So that was our concern. So that's why we thought that a secured bail should be set for these presumptive offenses.
It seems to me this bill, even with taking out this language, the opportunity for the Commonwealth to be heard, if there's a rebuttable presumption, it means a rebuttable presumption. Pretty clear, seems to me.
And I will respond to that. I understand that the bail folks want to make sure they get paid. And that's basically, I understand, I'm not trying to hurt the business, but I think a responsible magistrate can still use cash bail.
Sure.
And this would not prevent them from doing it. This bill in no way prohibits that. In fact, it's more likely than not that they would, because they want to make sure that the folks show up. So that will still be a tool in their toolbox. But I think under the circumstances, sometimes they get to hear the same thing that judges hear, if there's probable cause, the nature and the strength of the case. So I would ask that the bill.
Okay,
Senator
Morrissey.
Question for the bonds industry.
Yes, Senator Morrissey.
Do you have the bill right in front of you right now? Okay, look
Yes.
at line 62.
Yes.
Tell me why you don't agree with Delegate Scott. Where does that say that the judicial officer cannot set a secure bail? It just says may set or admit such person to bail.
Well, I believe they have that discretion. They also, the way I read it, and I could be wrong, but they also have the discretion to release a presumptive offense on their signature, which we call a PR bond or an unsecured bond.
So okay. I can almost promise you, guarantee you, let Senator Benjamin answer this, but if there's a crime so serious that it is under it's a rebuttable presumption, what judge or what magistrate do you think is going to release them on their signature? This language in here helps your industry. It sets a bond. I mean, you should be doing cartwheels. This is exactly what you want, and it's consistent with what the delegate wants, to allow people to be released on bail.
And I see your point. And our concern is more of a public safety issue. And, granted, there probably are many, many magistrates that would actually maybe continue to hold or do a secured bond on a presumptive offense. But, that we looked at it primarily as a public safety issue. Because I've seen a lot of things go on around the country, and I'm not advocating that this bill would create a New York situation, but that's how we viewed it, and that's why we wanted to speak on the bill. It's more of a public safety issue.
Okay, anybody else
Chair,
want to ask a question? Senator Morrissey.
The language in line 62 uses the words may set, or admit such person to a bail. I think it's good legislation. I'm going to make a motion to report.
Second.
Been moved and seconded
Mr. Chairman,
the bill be reported as amended. Yeah,
and just want to make sure the amendment says who is giving notice to the Commonwealth.
It doesn't specify that anybody is, although I can't imagine.
Right, the amendment removes the notice provision.
The judicial officer wouldn't invite the Commonwealth, right? Right? Okay. All right.
So,
Go ahead. Okay. It's been moved and seconded that the bill be reported as amended. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 8, noes 3.
Thank you.
8-3, the bill is reported, okay?
Thank you.
Thank you very much. Now, Delegate Bell, there you go. Oh, well,
I have an easy one.
no, good. We haven't come back
Mr.
to you
Chair,
yet.
good evening.
Temporarily. What? I don't know, where are we? Yeah, Delegate Bell, what's your?
I have
is that
House
you-
Bill 1118.
Isn't that Senate Bill, what, House Bill what?
House Bill 1118. It's a
1118.
combination. I'm
Okay.
sorry, when you're ready.
Yeah, go ahead.
So the Deeds Commission had two bills that came out of the Senate, 602 and 603. We did the same in the House. We had two bills. We decided they were so close to each other, actually, we should have just written them as one, and so we combined them into one bill. But unless staff disagrees, you have passed both parts of this exactly as it is unanimously already as the two hanger bills. And I'm happy to discuss it.
Second.
Are they identical, staff? Yeah, right, yeah, but they're the
Mr.
same.
Chair, this is, as Delegate Bell said, this encompasses both Senate Bill 602 and 603. There are some technical amendments that I would say make Delegate Bell's superior language, which they'll conform on the House side, but this is good to go.
But we don't need to amend it, right?
Don't need to amend
Okay.
it.
Been moved and seconded that House Bill 1118 be reported. All in favor of the motion, vote aye. All opposed, no.
Thank the committee. I'll be back with other stuff later. Thank you.
Okay, thank you. 11-0. Okay, Senator Delegate Hurst. Is he here? Yeah, here he is. Hokey Day Hurst.
And all that were left were the redheaded stepchildren, so.
For two of them.
We are not related, though. Of that, I can assure you.
It's a recessive gene caucus.
Mr. Chairman, members of the committee, I have before you House Bill 628. House Bill 628 comes to you over from the House, wanting to make clear that we want to try and end the practice of lawsuits that are filed against survivors of domestic violence, stalking, sexual assault, so that they don't have their abusers continue to use the court system as a way of furthering the abuse. So the practice that is occurring in Virginia and was brought to my attention by the Poverty Law Center, and they're here to help answer any questions as well, is that again, as I said, Mr. Chairman, members of the committee, there are individuals who are using the court process to file lawsuits when a survivor is, and by sake of example, filing a protective order statement. And those statements are then used against the survivor of domestic violence when an offender is about to be released from incarceration, for example, and you want to get a permanent protective order taken in. You are then seeing that these statements are being used.
Mr. Chair, if we can just cut to the chase, the language on lines 44 through 46, if you can prove to a court of competent jurisdiction that the suit either lacked justification in existing law or there was a good faith argument that supported it for any sort of extension, modification, or reversal of existing law, that if you can't prove that, the suit's presumed to be filed for an improper purpose.
Right.
You don't need it.
Mr. Chair?
Yeah, Senator.
This is going to do the exact opposite of what you want. Because if a suit's filed for an improper purpose, there's a lack of a factual basis, you already have a claim under 8.01-271.1. And so by laying out all these standards, you're actually going to make it harder to get a recovery in this case, because you're going to say to people that, were sued for intentional infliction of emotional distress, they could have had a recovery under 8.01-271.1 just under the typical standard that there was not a factual or legal basis. But now you're going to add all these aspects to it.
So,
I mean, and this is I hear the word Christmas tree over there. I think sometime, and I don't want to generalize, 8.01-271.1 is a uniform standard for all civil actions. And I think if you want to sort of make it agenda-driven, it's going to become a problem. It's just a uniform standard for all civil actions, and if you don't have a basis, you don't have a basis.
Mr. Chairman, to the senator, I would say that what this is trying to do, though, is make sure that when individuals have suits filed against them for statements that they're making, and hold on, that what is occurring is that they can't even get counsel for themselves to be able to then go into court and be able to, meet that lawsuit.
You're telling me about a problem. I'm telling you what is here is not the solution.
There's already a solution.
There is a solution right now.
Second.
Well,
This bill is not a
This
win.
is not really
This is not
a
a
slap bill.
Second.
This is not a slap bill, I don't believe. It's been moved and seconded to do what?
PBI.
Mr. Chair,
Pass
is
bill by a
there
different
someone
com-
here to speak
Yeah,
to the bill?
let's say, yeah, come up and speak
Can we
to the
hear
bill.
from her,
We need to
please?
hear that.
Sheila Varkey from Virginia Poverty Law Center. So this is the second year we brought this bill. Last year, it was in the immunity section. This is not expanding immunity. And it's actually just highlighting for the court the types of items they can pursue, right? So improper purpose covers these things and many more, right? So part of the issue is that victims are not able to get counsel and attorney's fees, et cetera. They're having to get pro bono counsel
Ma'am.
for these for filing criminal charges, for filing a protective order. We're talking about life and death
Ma'am, you're-
situations.
And I'm sorry to cut you off, but we've been here a long time.
I understand that, as have I.
I realize that, but these are uniform, 8.01 are uniform standards for all civil actions. And we set standards that apply to a defamation case, an intentional infliction case, a personal injury case, you name it, a commercial litigation. And when you carve out one and say, well, we're going to make this, for lack of a better term, to address a social issue or a behavioral issue, and we're going to treat those differently, first of all, you're not helping that problem. And you may think, well, I'm highlighting the problem, but you're making it more difficult to obtain relief. And I'm just telling you, I'm not being unsympathetic. And you and the delegate, I mean, I understand you're highlighting a cause that's critical, but these types of bills are not the solution.
Okay.
I'm just telling you right now, because this is what I do for a living. And I wouldn't say that unless this is what I do for a living. I'm just telling you, this is not the
It's
solution.
been moved and seconded that the bill be passed by indefinitely. All in favor of the motion, vote aye. All opposed, no.
All right. Thank you, Mr. Chairman.
Okay, thank you very much. 7-4, okay. Okay. Come on in.
Delegate Mullen is here?
Well, no, this
Think
is
he wants to
good.
be
No, he's
recognized?
finished. You can come after that. Go ahead. Yeah, delegate, yeah. Which numbers are yours?
Thank you, Mr. Chairman. I have House Bill 1544.
1544.
House Bill 1544 is substantially similar to Senate Bills 1089 and 1023 from Senator Morrissey and Senator Peake, which both passed 39-0 out of the Senate. They're all drawn to different code sections. So I've spoken with Senator Morrissey and with Senator Peake's office. We're going to get together offline and hash out the differences and come up with one version for all three. And so,
Mr. Chair, those bills didn't come through this committee, did
They
they?
came through Rehab and Social Services. 1023 of Peaks and 1089 of Morrissey's were Rehab and Social Services.
Mr. Chairman, I move to conform to something so we can put it
Well,
in
just a minute.
conference.
Let me find out. Why is, yes.
Mr.
Charles-
Chair.
Just a minute, Charles.
Sure. The differences between the two bills is Senator Morrissey's bill dealt with juveniles visiting Department of Correction facilities, and they couldn't be strip searched. Senator Peake's bill was basically dealing with, again, Department of Correction facilities and the procedures they have for visitors, which may have, I believe, included a strip search provision in part of a larger bill. Delegate Carter's bill is drawn to the 19.2 section, which would prohibit strip searches, I'd say more generally, but provide certain exceptions for juveniles who are within DJJ custody or other exceptions for strip searching as kind of provided in 19.2. So the bills are different in their application. I mean, the similarities are they both deal with, all three of them deal with strip searches for children, but the application of it are very different. I'd say if you wanted to conform, though, to get them in conference, I think I defer to Senator Morrissey to make that
motion.
I'm trying to get some, I'm looking at you and I'm trying to get some direction.
Hold,
Mr. Chair.
Yes,
Trying
Senator
to get some
Morrissey.
direction if you like the spirit of the delegates' bill, but you agree that it's, if one likes the spirit of the delegates' bill, but there are some differences, what, and we wanted to get that, would we be doing the delegate a disservice by simply conforming his bill to mine?
Mr. Chair, if I can answer that question, what I would say is, if you conform it to a Senate version and put the bills in conference, you might be able to work out the differences or come to harmonize all three bills in one bill, which may make it easier.
I'm going to make a motion, Mr. Chair.
Okay, Senator
We
Morrissey.
conform the delegates' bill to my bill, and that's my motion.
Mr. Chairman.
Senator Shore, it's been moved and seconded. Senator Shore.
Speaking to the motion, I see Delegate Carter nodding a lot, but can we get his commitment to try and figure out how to put our bills in conference so they can all be harmonized? Because I could see those two passing and then this one and it being weird, so.
Ideally, it'd be better not to put it in conference, but go ahead.
Mr. Chairman, Senator Surville, I've spoken with the chairs of both House Courts and House Public Safety. We're going to make sure that all three of these bills end up in probably an informal conference, and we get language distributed on all three so that we can all coalesce on one set of language.
Got it.
All right, right now, the motion is made to conform Senator Delegate Carter's House Bill 1544 to Senator Morrissey's bill, which is what?
1089.
1089. All right, that's the motion. Moved and seconded. Is there any discussion? All in favor of that motion, vote aye. Say aye, I'm sorry.
Aye.
Say aye, all right.
Move to report.
Now, it's
as
been moved,
conformed.
it's been moved and seconded that the substitute to House Bill 1544 be reported. All in favor, vote aye. All opposed, vote no.
Ayes 12, no 0.
Ayes 12, no 0. The
Thank you,
motion
Mr. Chairman.
carries. Okay, so now we have Delegate Mullen, you're the last guy here, last guy standing.
Mr. Chair, I have done that multiple times, so I appreciate the committee's time. Having consulted with members, I obviously would be willing to accept the Senate amendments if there was such a motion, but I understand that there's some.
Anyway, go ahead, finish your sentence. Finish your sentence before we have anything.
Yeah,
what else you're saying?
the other option?
No, I'm happy to accept the Senate amendments.
Okay.
Can I
all
just, Mr. Chair?
Yeah, Senator Peterson.
Can I just say, I'm glad, I didn't have anything to do with, I think this is a great idea, whatever you like is a great idea, delegate, so.
Well, thank you,
Proceed apace.
Senator, and I appreciate that. And it is an honor and a privilege to be able to appear before this committee, and so
Mr. Chairman.
No, he's doing it.
Okay.
Mr. Chairman.
Let's give each other a hug.
I've been moved and seconded.
Mr. Chairman.
I should have worn my bow
Substitute
tie.
Be adopted.
Hold
All right,
on.
Senator McDougal.
There is a substantive issue in the bill, and that is what is psychological torture? And I was just, we need to have that conversation so we know what we're now making a class 4 felony.
And so,
Mr. Chairman?
Yeah, let him answer the question.
No,
What
I don't
is psychological?
wanna-
No, wait, one at
yeah.
a time. The question was asked, what is psychological
So,
torture? Do you know-
Mr. Chair, if I would answer that, that would follow the Merriam-Webster's definition. So Virginia has not defined psychological torture, but there are 37 states that have defined torture in some regard, one way or the other. So right now, the example that I would provide to you is a case that is currently ongoing in Suffolk, in which a young girl who was 9 years old had her head shaved daily and was kept in a dog cage. She was fed properly and was allowed to go to school. But her diminution of her own personal will, of her own experience, and of her own personhood was such that that is something that I believe deserves something a little bit more than just 5 years.
Mr. Chair.
Is that defined as psychological torture? Is that what you think? I mean, because the question is psychological torture, is that right?
Mr. Chair.
Yeah, I want to answer, if you had anything else, in your view, that's an example of psychological torture.
And I believe that the courts have given common definitional language to common words, but I would defer to
Okay,
council
all right.
or to members
Okay,
of this
Senator
committee.
Well, Mr. Chair, I was just going to suggest, if this bill's reported, it has to go to finance. And so there's time between now and finance, whether
Monday.
that's first part of the week or whatever, to figure out whether we can come up with a precise definition of psychological torture.
Does anybody want to speak in favor of the bill or against the bill?
I move the bill go by for the day to Monday. This is a big deal, Mr. Chairman. This is like creating the strangulation standard, which every case turned into a strangulation. I think we need to carefully vet it and consider it needs to go by to Monday so we can have a real conversation about it.
And Mr. Chair, I would find that to be a friendly motion to be able
Okay.
to take it
Without
by.
objection, the bill will go by till Monday.
Thank you, Mr.
Okay?
Chair.
All right, okay, is there anybody else here? If not, it's only 20 minutes
Lord.
almost to 8. We usually go to 9, but we'll get out early tonight. Yeah, all right. The meeting is adjourned. The committee will rise.